The last paragraph said is paragraph 3. Just before that, however, Lordship has got.
Yes, yes.
However, the order of dismissal from service so and so has not been challenged in this writ petition.
Yes, that
Now-
means the court records that you have not challenged it.
Yes. Now that against that order, an appeal was filed. So
Yes.
that is just next page. In the appeal, the first paragraph says that he had challenged the order of suspension, and thereafter the appeal court goes on to at paragraph 14 of that appeal court order at page 110.
Yes.
Well, the court goes on to say, hey, hold that in such
Same thing. The order of dismissal is not under
Yes,
challenge.
yes. That was since
Is of no consequence.
well, since that was since the in the meantime while the suspension was challenged, there was an order of dismissal. This court did not entertain that. Now he has challenged that order of dismissal. Well,
How can you do it after 20 years? This is the question. What is your reply?
It would be said, my lord, that since he was in custody, while the entire proceeding was, let us understand, my lord, the entire proceeding was conducted while I was in custody.
Maybe, but then you did not challenge
My lord,
it.
either
You
he was,
sleep for
my
20
lord,
years.
either he was misinformed or misadvised that he
That
could not
is
do it, my lord.
a different
But
thing.
then at this stage, my lord, to say that, my lord, because there is a gross violation of principle, my lord, he was not even, he was in custody, he was not even, the order itself says that it was ex parte.
Maybe nothing.
And therefore I was in
Yes,
custody.
you
My
accept
lord,
it.
I have an opportunity, my lord, at least to challenge that.
After 20 years,
My lord,
you
even then,
become
my lord,
wise.
my lord,
All on a sudden, you have been given very good advice
2020
and you become wise, so you approach the
my lord,
court.
2024, he was misled. Your lordship will see that he only challenged the order of suspension.
This is what the court is wondering.
Yes,
Why
my lord,
only the suspension and not the dismissal when it
my
was
lord,
passed in
your lordship
2006?
will see that it was ill advised by the
Sorry, sir. That means you are raising allegation against the learned
I won't say
advocate.
that, my lord, but whatever
Obviously,
it is,
he was misled.
this is per se available from the records. I cannot my lord, do anything else, my lord. But I would only say, my lord, that the entire proceeding was conducted while I was in jail custody at the instance of the bank. At the instance of knowing fully well that I am in custody, they conducted the entire proceeding and dismissed me for service. Am I not entitled to just an order to challenge this, my lord?
Yes,
Maybe
you are, provided you come in proper time. It does not mean any time you can walk in the court and the court is going to stand by your side. No, sorry. What is your stand?
Right, my lord? Well, can it be said that the delay has vitiated?
Absolutely
I don't,
vitiated.
my lord, where there is a violation.
Yes.
Not this decision with the total abuse of the process of firstly. Secondly, inordinate delay. My lord, that is the why they have not challenged the discrimination. Because while he was service, he was caught for doing irregularities. Then he suggested an application for voluntary retirement, which was not accepted by the bank. Then he was informed. First of all, he was suspended. So he did not. The dismissal order did not challenge. He said because he had not accepted because it was not accepted by the bank. Basically, stated we informed him that it is not acceptable. Then on suspensions, he challenged the appeal court. When the appeal court he filed the writ petition in 2014, then in the 14 also he had to challenge. Then the order was there, dismissal was there. He did not challenge the dismissal order also. That time also, he went in appeal. Appeal court said, when you are not challenging the dismissal order.
That's what I said, my lord.
So there, all through he wanted to encash that he has voluntary retirement, so disability cannot proceed because employer
He has not even participated.
Till the application for voluntary retirement is accepted, how can he say that he has been voluntarily retired? He cannot say that.
That you have advised him. He said no. By giving 3 months of allowance, I will retire. So I will not participate in the disciplinary proceedings. Disciplinary proceedings, charge sheet, everything served on him through the jailer, and he challenged the suspension order, but he did not challenge the dismissal because
you file a report and give all these details.
Yes.
So that it
All
can
these
be.
things are there. All these things are there. In the affidavit I am filing. Affidavit which I filed was showing me that what actually.
Where you have filed the affidavit in the other matter?
No, in the ordinary writ petition.
That is not in this one.
Not in
This
this,
is
no.
a new one. You file a report. All right. file a report by way of affidavit giving all these dates and the details so that it can be dealt with. Because this is also being carried in appeal, will be. Right? So, till the dates are here.
They have sent a letter and we have replied the letter. Madam.
Where is it?
That they have last hearings.
That page 140.
One the letter in 2025. That is the page
25.
141.
Ah,
That is their letter.
yes.
And we have replied to the letter, my lord, at page 148. You would find
Yes.
the petition, this is.
Yes.
The letter will mention something like that.
You only
Mention
said that I'm not
something.
entitled.
All right, you give me a list of dates type of things so that I can get to know how it proceeded. Please come.
The only thing he wanted to is that he has submitted voluntary retirement.
You.
So therefore, nothing, no disciplinary can be proceeded against.
All right, you give all these things.
To anticipate a defense.
The
Whether he's
petitioner
anticipating, I have not participated in the proceedings.
is a dismissed employee of the State Bank of India. Stop. The order of dismissal was passed in the year 2006. Stop. The petitioner, though challenged the order of suspension, comma, but did not challenge the order of dismissal. In the earlier writ proceeding filed by him in the year 2014. Stop. The writ stood dismissed and the order of dismissal was affirmed by the Honorable Division Bench. Stop.
Suspension, madam.
For the first time, comma, the order of dismissal has been challenged by the petitioner by filing the instant writ petition in March 2026. Stop. It has been submitted that there has been violation of the principle of natural justice. Stop. No opportunity of defense was given to the petitioner. Stop. The entire proceeding was conducted when he was in jail custody. Stop. Prayer has been made to set aside the order of dismissal on the ground of violation of the principle of natural justice. Stop. Learned advocate for the bank opposes the submission and prayer of the petitioner. Stop. It has been submitted that the instant writ petition is a gross abuse of the process of law. Stop. The petitioner was all along aware of the disciplinary proceeding and he deliberately did not take part in the same. Stop. The writ petition is filed after an inordinate delay and the same ought not to be entertained. Stop. Paragraph. Prima facie, the court is of the view that the writ petition has been filed nearly 20 years after the order of dismissal was passed in the disciplinary proceeding initiated against the petitioner. Stop. The to allow the bank to revert with a written report by way of affidavit disclosing the timeline of the disciplinary proceeding, comma, the court directs the bank to file a report by way of affidavit within a period of 4 weeks. Yes, yes. Exception, if any, may be filed within a fortnight thereafter. List immediately on completion of the aforesaid time period. 4 and 2, 6. Calculate, date will be fixed. Yes, yes, they'll do it. Today is 8th. 1, 2, 3, 4, 5, 6. It's 20th of May. It will appear on 8th of June.
Great.
List on. Services. on record.
But in this matter, directed that if you can connect with the department and the authority ministry. I have personally done so, my lord. My lord, this will take a little time.
What thing?
That whether they can be taken as a one-time measure.
One-time measure. Well, then I can give you time, provided you give little bit of assurance that yes, positive thing can be done.
This is the seriousness with which I have done. I have personally said. Not left it to the junior. I have personally asked them to treat it.
And what is their
No reply till now because this actually this takes time. Your ministry level thing, it will take a little time. And I think I have
1st of April?
yes, the day my lord passed the order, I had immediately on that evening sent it. My lord gives me 2 weeks time.
All right.
2 weeks as of now, 2 weeks.
On the prayer of the learned advocate representing the respondents.
No, doesn't do that on the prayer, if possible, my lord.
No, I keep it so that there is some urgency which you can show to them. Apropos your letter. Got it?
And also
revert
that
with-
after matter is heard.
To revert with further instruction in the matter.
Yes.
As to whether, as a one-time measure, steps can be taken for regularization of the 3 petitioners. Comma, released for further consideration on 6th May. I give you more time.
Then
Today is 8th
then
of
not 6, then 13. I am not there. Oh my lagbe janis tu yo jan.
12th of May.
The only difficulty, my lord, is that there are.
I found out their retirement all have more or less 10.
No, I'm not on that, my lord.
10 years.
Almost 10 years.
No, Lord, I'm not on that retirement age, my lord. I'm on the point that we are going closer to the vacation, my lord, and if
Yes.
there is a change in the bench,
Nobody knows.
again, what happens is, my lord,
This
3 different, my lord, coordinate.
I understand, but then the court is trying to see if it can be sorted out.
That is my
And as soon as possible, it is done.
my lord, 12th is a Tuesday, my lord. It kindly keeps it on 13th.
Why? What is so special on the
It happens
13th?
on Tuesdays and Thursdays.
All right, 13th. No explanation sought.
The division bench matter.
No explanation. Yes.
That I represent the petitioner.
Yes.
But I understand that the facts have been elaborated before your lordship, not in so far as the disciplinary action is concerned. And I just formulate the points not in 3 or 4 manifolds, and I will not close the submission. But I have prepared a short notes not indicating the sub points not to be urged in the matter.
Separate notes.
No, same. Not she has already
No, this is a list of dates.
has
This
given
is
a list of dates. Not I believe. এটাই তো আমার এইটা এই অনুযায়ী করছো না কেন তুমি তাহলে আবার করলে কেন
Yes.
I mean, the first point is lack of jurisdiction. Now, chapter 1, rule 3 identifies not the disciplinary authority in respect of judicial officers of the appellate side rules. Now, which is the full code.
Which point are you raising now? Number 1 is something else. This is the
কেন চেঞ্জ করো
chapter 1, rule 3.
করলে না কেন ছেড়ে দাও শোনো এই ফর্মুলাটা করতে কি অসুবিধা হলো আমি তো বুঝতে পারলাম না। প্লিজ কাম টু point number 4, page 2.
Yes.
Just
Lack of jurisdiction.
when the disciplinary authority is the full court, not the administrative committee.
Mhm.
Now that's in chapter 1, rule 3.
Hmm.
Now the charge memo dated 20th January 2022. Not the he has already placed before your lordship the charge sheet, but vis-a-vis the disciplinary action initiated, there is no reference to a full court meeting. Be that as it may, the charge memo is dated 20th January 2022, issued by the Registrar General, referring to only an AC committee meeting. So not there is no reference to full court committee, a full court meeting, unless not the administration produces a decision to that effect. But in the opposition, there is no such disclosure. But of course, not this point has not been specifically taken in the pleading, but not it's a point of law. Now, not the appointment of EO before issuance of charge sheet. I'm sorry, even before charge sheet on 22nd of September 2021.
And which is this point?
আমি এইভাবে বলেছিলাম রতিকান্ত, জাস্ট টাইপ করে দিতে বলেছিলাম।
If you want to prepare it in a better way, you can come back.
My lord, please allow me to do this. Now, this will be all the more crystallized manner.
Yes.
কেন এটা করছো না বারবার করে বলছি আমি?
Then you take this back. I do not want to. take
It will only
also.
burden that.
Yes.
এটা অনেক ছোট হয়ে যাবে তো জিনিসটা। Just এই ফরম্যাটে ফিল দাও।
Next week?
My lord. But it can be done not in 1 or 2 days time.
Yes, 1 or 2 days. Today is Wednesday. So we come back next
My
week.
lord.
Not this week.
এইভাবে ধরে ধরে গেলে শুরু Not appear for the petitioner. Notice kindly treat not item number 7.
Item number?
Kindly treat item number 6 as the lead matter. But these are all similar matters. Notice
All right.
6 I am led by Mr. Mukherjee.
Shantanu Mitra.
No. Item number 7.
Pradut Kumar Chattopadhyay.
Right. Kindly pardon me, Mr. Majumdar, my lord. I have some difficulty in speaking.
All right.
Kindly. Somo,
Spartans to stepping up of pay of class 1 officers in Kolkata Port Trust.
Yes.
This stepping up was necessitated by reason of juniors getting a higher pay on revision coupled with bunching increments being conferred upon them. But what was bunching increment? Not I have prepared a diagram not for your lordship's not kind consideration, but this will not immediately bring things not to your lordship's memory. But please take what is A. Not I have classified it into 4 parts: A, B, C, and D. These are the pay scales. A pay scale is recognized as non-standard pay scale, which is 9,100 to 15,100.
Hmm.
B is the standard pay scale, which is recognized by the figure of 10,700 scale of 10,750 to 16,750.
Hmm.
But this was revised as on 1/1/2007. B was revised to C 20,600 to 46,500. But this had an annual increment of 3%. And D is the current the pay scale currently in operation. That's the 7th pay commission stage.
Standard and non-standard are two different set of employees.
Yes. Now, but at one point of time, Kolkata Port Trust, like other CPSCs, were not the officers of Kolkata Port Trust, like other CPSCs, were not getting the same pay scale. So since 1992, and there was a 5-yearly revision at one point of time, but from 1997, this was revised after every 10 years, like other public sector undertakings. So the central government took a conscious decision with the approval or concurrence of the finance ministry that the pay scales of these officers should be brought at level with the other CPSCs. So now what is 9,100 to 15,100 was the non-standard pay scale, meaning which was not at standard with the other CPSCs. That has been referred to in the judgment.
Now, standard pay scale is the 10,715 to 16,750, which was enjoyed by the other officers in other PSUs. Now, but not in KOPT, that's Kolkata Port Trust, 10,750 was the promotional pay scale because
Of the non-standard
of the
one.
non-standard employees.
All right.
Now, please have a look at the chart. This non-standard pay scale had an annual increment of rupees 250.
Hmm.
And the standard pay scale had an increment rate of rupees 300. Now, in this pay scale of A, there were at possible 6.5 increments were possible, not from 9,100 to 15,100. Not I have calculated this, not this goes on to 10,600 up to the sixth stage, and therefore it comes. So the conscious decision was to replace A scale with B scale and then revise it with effect from 1/1/2007.
Even if the 6.5 increments were not there, still also this revision will
But
go.
I will come to this. So the entire pay scale was sought to be replaced on 31st of December 2006. And then what was B was revised on 1/1/2007. The scale was revised.
Yes.
Now, in the scale, there would be various stages of pay, apropos the pay fixation of individual officers.
Yes.
So, whoever was getting 2 increments in scale B,
Yes.
in the revised scale, he was given 1 increment to protect the mark of distinction. So, particular pay point was differently fixed in the revised pay scale on routing it through the standard pay scale. Non-standard routed to B and then revised to C. But the pay points were appropriately fixed by giving for every 2 increments earned in the non-standard pay scale, 1 increment in the revised pay scale as on 1/1/2007.
All right.
This was commonly called bunching increments. Otherwise, whoever was getting, say, 9,850, say 10,100, please come to the stages mentioned.
Yes, yes.
He would be brought to the level of 10,750.
Yes.
Like an officer who was getting 9,350 or 10,600, everybody would be bunched together. So, the mark of distinction earned during the length of service was getting obliterated. That's why a conscious decision was taken that for every 2 increments earned in the non-standard scale, give 1 increment in the revised scale. Now,
2:1 type of thing.
2:1. I'm grateful to you.
All right.
Now, this was sought to be taken away in 2016 by the central government, although it had the concurrence of the finance ministry. So, the employees approached this court through a writ petition. Ultimately, up to the division bench, the writ petition has been allowed. The appeal filed by the Kolkata Port Trust and Ministry had been rejected. The matter has gone up to the Honorable Supreme Court. Now, in 2014, there was a conscious decision to implement this stepping up. Why this stepping up? Not the officers who were junior might be getting a higher pay by reason of this revision and fitment. So, whoever was senior to them, they were brought at level with the junior officer, not surpassing that. Now, this was in accordance with Fundamental Rule 22 and 27 of the FRSR. But not the KOPT had no qualm with this. They wanted to implement this, and this was in fact their recommendation, that the mark of distinction and the seniority of the senior officers cannot be disturbed by this implementation of pay revision or not pay fixation even. So, they wanted to implement this stepping up provision. Ministry said no. This stepping up cannot be allowed because this is not a case of promotion. FR 22 applies to promotion and FR 27 applies to early increments. So, these are 2 provisions which can be employed for the purpose of stepping up in respect of central government employees. So, KOPT cannot implement the provisions of stepping up. Now, this has resulted in this batch of writ petitions. But of course, the matter has gone up to the Honorable Supreme Court from the division in judgment of our court, upholding the implementation of bunching increments. But in one of the writ petitions, KOPT has taken, Ministry has taken a stand that no, this has got nothing to do with the bunching increments. Stepping up has got nothing to do with the bunching increments. I shall refer to that particular provision when I place it in detail. During the pendency of the Supreme Court matters, even before that, Now, there was a conscious decision taken by KOPT through its highest offices that stepping up can be agreed in respect of those officers who are intra-departmentally situated. Suppose not engineering division. Whoever is junior will not be getting a higher pay. So the engineering division senior will be stepped up to the level of junior officer. But if it comes to engineering versus administration, this will not be done, although officers are being transferred from one division to another and from one port to another.
Are being transferred.
Are being transferred. This is an admitted fact. Now, this has resulted in a situation where intra-departmentally circumstanced officers are getting the benefit of stepping up, but interdepartmentally situated or circumstanced officers are not getting the benefit of stepping up, resulting in an anomalous situation where the junior who had been working under me just a few days back, but placed, say, in the finance division, and I'm moving from administration to finance, I will not get the benefit of this stepping up.
But then if from one department to another, these transfers are on, then there is bound to be anomaly.
That's my point. But I just showed your lordship only one document from the the KOPT's stand, and not the stand taken by port before the Honorable Supreme Court. Now, please take a supplementary file. But I have copies of cases. But these two documents were not before the court before. But I seek your lordship's leave to file this supplementary affidavit disclosing only two documents. Copy documents.
Yes.
Not the first two documents are interim orders passed by this court, staying not the effect of recovery. Please come to page 55 straightway. This is part of SLP filed by port.
Is it in the supplementary or the writ petition?
Supplementary. But I just show not the latest stand of the authorities before not I proceed further.
All right, 55.
Please come to not page 55.
Yeah.
And may I place from not I'm sorry. May I place from 54? No, that's paragraph H.
Yes.
Subsequently, the Ministry of Shipping issued a corrigendum dated 3rd August 2010 modifying the pay revision order dated 26 July 2010. The corrigendum provided that the replacement of non-standard pre-revised pay scale of 9,100 to 15,100 by standard pre-revised pay scale of 10,750 to 16,750 would be subject to the suitability of the incumbent officer to hold the said upgraded pay scale. In simpler terms, the suitability of the incumbents to hold the upgraded pay scale was a prerequisite, and only if they were found to be suitable for promotion, they were entitled to upgradation from pay scale A to pay scale B. Now, this is one stand. So,
what is this?
This is part of SLP filed by the
part of the SLP.
Filed by Port Trust before the Honorable Supreme Court. It runs from pages 43 to 108. This is the relevant portion.
All right.
Now, please come to page 109, which is the KOPT's internal note regarding stepping up.
Yes.
10th October 22 on the subject of bunching increments and stepping up benefits regarding. On consideration of the representation received against this office letter of event number 27 September 22 in connection with implementation of order dated 16 September 20 of the Honorable High Court at Calcutta in WP number. This is the lead matter where the Honorable Court upheld that bunching benefits. In terms of directive of Ministry of Port and Shipping, while later dated 4 July 22, it has now been decided in partial supersession to this office letter of event number dated 27 September 22 that the undertakings to be submitted by the serving officers or former officers, including pensioners, family pensioners who are or would be the beneficiaries of bunching increments and or stepping up benefits, should be for the amount which would now be paid in lump sum as arrears, and the additional money to be paid every month, though through salary or pension or family pension as the case may be hereafter. However, the phrase quote unquote additional money to be paid every month in the previous sentence is not applicable for serving officers in receipt of bunching increments. For the beneficiaries of stepping up benefit, excess amount already paid recovery of which has been stayed by the Honorable Court, should not be adjusted against the arrears to be calculated now. So, the undertakings from the serving employees, former employees and family pensioners should be for the following amount. Bunching, please see what is the first column, bunching increments. Serving officers arrears maximum up to rupees 5 lakhs. Former officers arrears maximum up to rupees 5 lakhs plus monthly additional pension. Family pension, we are not concerned with the last two columns, not we are concerned with the serving officers in this case. Please see the next column, stepping up benefits. Arrears maximum up to rupees 5 lakh plus monthly additional salary to be paid now onwards. So not this cuts across not departments. It does not refer to any departmental or not intra-departmental officer. Now at page 110, this has been issued with the approval of the chairman. Clause paragraph number 2. This is the issue as to whether this can be granted to us or not. But I have shown to your lordship not the stand taken by Kolkata Port Trust. Now the question comes not whether this can be decided at this stage or not. But please have not a copy of list of dates.
At this stage means?
During the pendency of the SLP.
All right.
Because that subject matter refers to the bunching increments and stepping up.
Which is pending?
Stepping up, not stepping up is pending. Bunching increment
is pending.
And that's the stand taken by Kolkata Port Trust before the Honorable Supreme Court.
And tell me one thing, are you all in any particular department or anything?
No, these are all cutting across various departments. And what one important aspect
but isn't bunching up and stepping up, this bunching and stepping up have effect on each other? If that be
stepping
so,
up would be consequential. Otherwise,
yes.
As your lordship has been pleased to find from that stand of KOPT, whoever was eligible to hold the higher pay scale as on December 2006 would be entitled to this upgradation of the standard pay scale. Upgradation and then revision. Now, not everybody, all the petitioners before your lordship was in the standard pay scale of 10,750 as on December 2006. So, not, there comes the question, not whether this, but the bunching increment had been given to those employees who were in the non-standard pay scale. All of us were in the standard pay scale or the upgraded pay scale and seniors.
But even it comes to my mind that maybe it will have some bearing with the matter which is pending over there. So will it be proper to hold the court? Because this matter is going to take time.
Yes, one is in the first matter, in paragraph 18, Union of India has taken a stand that bunching is a non-issue in stepping up. That's their stand taken in the opposition. But there may be an impact of bunching on stepping up, because if bunching is taken away a block for all the junior officers who have moved from the non-standard pay scale and upgraded to the standard pay scale, then stepping up may not be reconcilable with this pay structure. But there is a stand taken in opposition by Union of India that this is a non-issue. But Union of India says bunching, stepping up can be given intra-departmentally. So for the intra-departmental officers, they treat it as
they do not have a problem.
KOPT decides that even for inter-departmental officers, it can be granted subject to a capping of 5 lakhs and with an undertaking to be taken.
Yes.
Now that's the decision which I am seeking for implementation at this stage, like the other officers. Now,
has the union entered appearance?
Yes.
Is the union a party also?
Yes.
Oh, you are there.
Now, if your lordship will kindly have a look at page 132 of the writ petition, item number 11 of my list of dates, at page 2. These are the stepping up guidelines.
Yes.
Kindly have a look at page 132 of the writ petition now. And this is applicable to the These are DPE guidelines, not the central government's ministry's guidelines as such.
Yes.
It's an office memorandum of 27th November 2012.
Yes.
Subject is stepping up the pay of a CMD or MD in a CPSE in case the pay of a director in same CPSE fixed more than CMD or MD as on 1/1/2007 because of benefit of bunching of increments.
This is by the Department of Ministry of Heavy Industries and Public Enterprises.
But in respect of CPSE.
Yes.
Now, normally, DOPT circulars would be applicable to the government employees and DPE guidelines would be applicable to the CPSEs. But not ministry has clarified this solely for the purpose of CPSEs in relation to stepping up arising out of bunching.
In the heavy industries, isn't it? But then I do not know.
No, it's Ministry of Heavy Industries and Public Enterprises, Department of Public Enterprises. It's Department of Public Enterprises. DPE.
Huh?
This is stepping up of the pay of a CMD or MD in a CPSE. In case the pay of a director in the same CPSE fixed more than CMD as on 1/1/2007 because of benefit of bunching of increments. So this is a issue specially devoted for the purpose of CPSE and related to bunching or stepping up arising out of bunching.
All right.
The undersigned is directed to refer to para 2(3) of the DPE OM dated 26 November 2008 relating to the benefit of bunching of increments to below board level executives. Thereafter, para 3(1) of DPE OM dated 24 September 2010, board level executives were extended the benefit of bunching of increments. However, the benefit of bunching of increments has not been made available to CMD or MD of a CPSE, as the post of a CMD or MD in a CPSE is a stand-alone isolated post. An anomalous situation arises where after 2007 pay revision, the pay of a CMD or MD gets fixed at a lower level than the directors of the same CPSE by virtue of the latter getting the advantage of bunching of increments in the revised pay fixation, even though in the pre-revised scales the CMD was drawing higher basic pay in comparison to the director of the same CPSE. Not similar is the case here. The issue has been examined in DPE. It is now decided that in the event of an anomalous situation as given in para 2 above, the pay of a CMD in a CPSE would be stepped up to the level of the senior-most director of the same CPSE, subject to the following conditions. The CMD and director were on the rolls of same CPSE before or after 1/1/2007, not similar case here. On adoption of 2007 pay revision, the pay of the senior-most director of the CPSE gets fixed at a level higher than that of the CMD by virtue of former getting advantage of benefit of bunching increments. Same issue involved here. CMD was drawing higher basic pay on 1/1/2007 before pay revision as compared to the senior-most director of the same CPSE, not non-standard upgraded to standard and then revised, same anomalous situation. On implementation of 2007 pay revision, the basic pay of CMD or MD is fixed lower than that of the senior-most director of the same CPSE. But that's why not that bunching increment was given. All officers getting higher pay at the non-standard pay scale got clubbed or bunched at a particular level in the revised upgraded pay when it was routed through B, scale B. That's why bunching, that's why stepping up. Now, now please come to page 137. No, read. No, it's the memorandum begins at page 133. Lordship may straightway come to page 130. No, I'll show to you, Lordship, not the subject matter of this memo. 14th December 2012. Finalization of terms and conditions, including pay fixation, in respect of board level executives of CPSE's revised procedure thereof. Lordship may straightway come to page 37. 137 clause, no, I'm sorry, 135 clause 5 first.
The earlier one was November 12 and this is December 12.
December 12.
All right. Page 137.
135 first.
5. All right.
Now, this comes under the broad caption C. No, I'm sorry, it's an independent. While fixing the pay of board level executives of CPSEs, the following points will have to be taken into consideration. But these are the basic principles. The last pay drawn by the incumbent should have been drawn as per DPE guidelines. If any stagnation increments were given to the executive either in 97 or in 2007 pay revision, the same should have been granted only after reaching the maximum of the prescribed scale. But the first sentence is important. Last pay drawn should have been drawn as per DPE guidelines. Then 2, any personal pay, additional increments or any increase in pay granted in any pay scales are not to be taken into consideration for pay fixation as they are aberrations from DPE OMs. Now, this is not related to this issue. Now, please come to 137 straightway. Paragraph 9. The pay fixation principles which apply in respect of board level executives of CPSEs would also be applicable mutatis mutandis in respect of below board level executives and non-unionized supervisors of CPSEs. However, the date of accrual of next increment in respect of board level executives of CPSEs who are contractual appointees and appointed on fixed tenure basis will be the anniversary date of their appointment as already provided in DP model terms. So, what page 132 envisaged was stepping up of pay of MD or CMD. By this page 137, it was made applicable mutatis mutandis to all below board level executives and non-unionized supervisors as well. I am not read this with page 135. It says that pay should be fixed in accordance with the DPE guidelines. So, this is a special directive issued by DPE for the purpose of pay fixation of individual officers. Now, if there is a conscious decision adopted by the central government does not object to this stepping up if it is confined to the intra-departmental officers. Now, I have not read these two circulars of 2012 read harmoniously with the central government's decision. This has to cut across all departments for the purpose of pay protection. Not pay protection, but to maintain the seniority of pay. Parity of pay. Otherwise, it creates a adverse position with the status of an officer.
What exactly is the issue before the Supreme Court?
Not that bunching. At one point of time, QOPT fixed this pay scale from the non-standard to the revised pay from particular pay point. Say one, please take that chart. I know your lordship's views. May I just call only one of the officers in court? It's a pay scale matter. I should get it.
I was just thinking whether to take up the matter or not. Should I wait for the Supreme Court matter?
No, I have. So, in the note, there is a possible answer given to the queries which may arise from the court, and my most humble understanding or not apprehension. But there are 4 points addressed in the note. Your lordship will kindly consider this later on. Please take that chart. Your lordship was asking this question to me as to how this bunching was fixed or was granted. Now, please take a stage 2 officer who was drawing 9,600.
Right.
There was an increment of 2,500 in the non-standard pay scale, apropos 3,000.
300.
I'm sorry, 300 annual increment in the standard pay scale. Now, at one point of time, decision was taken that an officer who was drawing, say, 9,600 at stage 2, he would be directly fixed in the C scale. That's the revised scale.
20,600?
Yes. Without routing it through the standard pay scale.
Without routing it through B.
So, the question came for consideration as to how could he be revised at a pay scale at 1/1/2007 from a pay scale which was not existing as on 31st of December 2005 or 6. Because this non-standard pay scale was bodily or in effect substituted by the standard pay scale. So at one,
suppose you read out, or the illustration was in respect of stage 2. Now in 3, 9,850 someone is getting.
Yes.
He will also go to 20,600.
Yes, and would be placed at the third stage of that pay scale. three increments. He had earned three increments.
Uh-huh.
So three increments of after 20,600 at 3% per annum. That would be his pay point fixation.
All right.
Now,
But the basic comes to 20,600 and then the annual increment is there.
so not everybody who was then not the question was addressed to by answering in this manner that there was no pay scale of 9,100 to 15,100 existing prior to 1/1/2007 insofar as port is concerned. So you have to compulsorily route it through the standard pay scale before implementing the pay revision of 20,600.
So this issue will be there throughout the country, isn't it?
No, it's done for the Mumbai Port Trust is getting that, Jawaharlal Nehru Port Trust is getting this.
Then why is Kolkata?
We are the pioneers. Mr. Mukherjee had argued it at length. Before this honorable court, he had argued this at length. A conscious decision taken. Those were the 2 points. A conscious decision taken up to the highest level could not have been taken away by a file noting. Number 1, the file noting did not contain any reason. Number 2, a benefit given with a conscious application of mind could not have been retrospectively affected in an adverse manner. On these 3 principles, we had been able to persuade this honorable court up to the division bench that there could not have been an adverse affectation of right, and that too with a retrospective effect insofar as pay fixation is concerned.
I will not go further because my time is over. But still, I'll ponder on this point whether to hear it or not.
Yes, your lordship will kindly consider after page 3 of the list of dates.
All right.
At a list of dates.
Please come. Learned Senior Counsel for the petitioners commences argument. Stop. When do I keep it?
Not tomorrow.
No, certainly not tomorrow. 22nd, fortnight.
Late will your lordship below.
Yes. One more thing. Yes, please do. First matter. All separate orders will be passed. This will be Pradut Kumar Chattopadhyay. Order will be passed in this matter. And item number 5, the opposition by the Union of India be taken on record. Was copy served and reply filed? Reply filed, please check. All right.
Grateful to your lordship.
Check up whether you filed the reply to item number 5. Then it's all right.
Lordship, may I permit to mention one matter at adjourn motion, Lordship?
Adjourn motion?
Yes, Lordship. This matter, Lordship, has been heard by the Honorable Justice Shogoto Bhattacharya, and the matter has been.
Is the microphone working?
Yes. Lordship, this matter has been heard by the Honorable Justice Shogoto Bhattacharya, and the matter has been fixed on to 18 March 2026, but matter has not been listed, Lordship. Thereafter, I am praying, Lordship, is a dismissed employee, Lordship, 2026.
No, but then today and right now is certainly not the time. I have accepted mentionings, not now.
Yes.
Call.
My lord, I appear for the petitioner.
Yes.
My lord, on the last occasion,
1 minute, I have prepared my judgment. I'll only deliver it. Wait. The court has directed the authority to re-verify its record to find out as to whether the certificate that you have relied upon, the medical prescription, was actually placed by the petitioner before the authority at the time of hearing. Otherwise, also, the authority may consider as to whether production of the disputed document will make any change in the punishment that has been imposed upon the petitioner. And the direction for verification, re-verification of records is passed with the idea of removing any doubt in the minds of the parties with regard to the production and consideration of the disputed medical prescription at the time of considering the case of the petitioner. A member of the force should not harbor the feeling that all documents were not verified prior to passing the order of punishment. The authority will also get an opportunity to recheck as to whether there was any genuine reason for the petitioner to remain away from duty. So the authority has been directed to re-verify at the earliest, but positively within a period of 4 months from the date of communication. Until the verification is done, the order of punishment is directed to be kept in abeyance. But then it is abundantly made clear that the authority would be justified in passing necessary order for maintaining discipline and a sense of responsibility in the members of the force. Any casual or indisciplined attitude in the force ought not to be tolerated at all, in view of the fact that the members of the force are charged with the responsibility of ensuring border security, and any lapse on their part may lead to cross-border issues. All right.
My lord, if the prescriptions are genuine, then let them pass an appropriate order.
Yes, certainly.
Much obliged.
The order will be put up in the server. You can get the details from there. The chamber apartment. Yes, item 2.
I'm for the petition.
In this matter, direction has been passed for filing affidavit in opposition within a period by 7th of May, reply by 22nd of May. And all objections raised by the respondents, including the issue of maintainability of the writ petition, is kept open to be decided at the time of hearing. But at the same time, the court has passed an interim order. The court has directed the respondents to keep in abeyance the relieving order dated 23rd March 2026 till 26th of June 2026, and the respondents have been directed to permit the petitioner to rejoin service with immediate effect and positively by tomorrow. All right. The order will be put up in the server. Please check out the details, and tomorrow is the date for joining. This is by way of an interim order.
Only one thing, my lord, the petitioner is a native of Himachal Pradesh.
He is not here now?
Not here right now. If you also kindly extend the time so that he can come and join.
But then he was there on the last
Yes, he
occasion.
was there on the last day. For some reasons, he has gone back to Himachal Pradesh. So if you also kindly
How
allow me,
soon?
as your lordship will direct, I will inform him. He will come
I had kept it tomorrow because this is going to have an impact in the break in service period also. So
within 2 or 3 days. Within 2 days he will join. 2 or 3 days.
today is 8th. I keep it on Friday, 10th. Not more than that.
I'm so grateful to your lordship.
Yes, please.
Submit. Where am I doing a submission? Because the writ petition has been filed after he has signed his relief.
That has been taken into consideration also over here. All right. Order will be there in the server. Check the details.
My lord, we shall. Grateful to your lordship. May it please your lordship.
Yes.
BSF constable
Hmm.
service terminated on the ground of unauthorized absence without any proceeding. Lordship will first come to the show cause notice, Lord, at page 26. Page 26, Lord.
Has copy been served?
Yes,
Yes. Page number 26.
26, Lord.
Right.
The show cause notice dated 27 December 2022.
Yes.
Paragraph 3, if you have anything to urge in your defense against the proposed dismissal from service, you may do so within 30 days of receipt of this notice, failing which it will be assumed that you have nothing to urge. And 4, a copy of the court of inquiry above is enclosed for your ready reference. This was never enclosed, my lord.
Hmm.
The first point that I'll be showing your lordship, never enclosed.
Hmm.
Then, my lord, the order.
Did you bring this to the notice of the authority that it was never enclosed?
My lord, I think it was said, but my lord, lordship kindly looks at the order. The final order which was passed.
No, this is a show cause. Where is your defense?
My lord, it was not given, but they had sent a person. I had said something that will emanate from the documents, my lord. My lord, kindly comes to page 27.
Yes, please.
The final order.
Yes.
My lord, at paragraph 2, it is clearly said that he has failed to submit any reply to the show cause. Then,
All
my lord,
right.
considering the matter in its entirety, I am satisfied that so-and-so has been without sufficient cause overstaying leave since 2910. I am also satisfied that his aforesaid continued illegal absence is contrary, and so on. Then, my lord, the period of absence be treated as dies non, and as per Rule 28, capital A of the BSF Rules 1969, my lord, I had handed over a set last. In case number so-and-so, considers himself aggrieved by this dismissal order, he may file petition to the Inspector General, South Bengal. He is struck of strength from this unit from 4 to 2023. Now, my lord, lordship kindly comes to my appeal to the Inspector General. Next page.
Yes.
With due respect and regard, I beg to state that on so-and-so prayed for 10 days leave, which I urgently needed on account of my domestic problem. Said leave was granted by the concerned authority from so-and-so. But as the leave was going to be over on so-and-so, my uncle-in-law, my wife's maternal uncle, expired all on a sudden due to heart attack. As he was my close relative and no other persons was there to stand by the tragic family, I had to extend my cooperation and help to them to collect, to stand by that. I had to help them to collect the death certificate and perform the last rites. In the meantime, my wife engaged to me with domestic quarrel and leaving my minor son aged about 2.5 years to her paternal house, and it took long time to end my family problem to bring back my wife to my house. After that, my wife fell seriously ill due to a left-handed tumor. After being disappointed to visit many local doctors, finally I went to consult a doctor named so-and-so in Malda, and he advised expensive surgery which I could not afford due to monetary crisis. So the doctor prescribed some medicines with advice to get this.
Yes. Then what happened?
Now, my lord, next page, lordship sees. Then on 2/2, I received a notice from my department asking me whether I would join my duty or not. My lord, someone was sent. I'm coming to that. I gave a positive response. Unfortunately, and 4/2, the concerned authority of my department sent dismissal or notice to me that was received by me on so-and-so. But here, this will come out from the order passed by the appellate authority. Page 33, my lord, annexure
Yes.
P8. My lord, I would just humbly beseech your lordship to consider that here, my lord, it was not that I was absenting from duties unauthorizedly, definitely, but with because of family problems, etc. That was brought on record. Well, Lordship kindly comes to the order of page 23, 23rd June 2023, paragraph 2. Whereas the petitioner neither joined his duty nor apprehended by the police authorities, therefore the commandant proposed to terminate the service of the petitioner as per the provisions of Rule 22(2) of the BSF rules, as his continuous absence from duty was affecting the discipline of the force. Accordingly, a show cause notice was issued to the petitioner, letter dated 27/10. A representative of 117 Battalion BSF also visited the hometown of the petitioner and met him. During meeting, the petitioner handed over an application addressed to the commandant 117 to the representative of the unit, wherein he stated he will join duty on 4/2/2023. However, the petitioner did not turn up to rejoin his duty. Thereafter, considering the matter in its entirety, the commandant was satisfied that the petitioner's prolonged illegal absence is contrary and as detrimental, and his further retention in force is undesirable. But here only one thing. When he went to join on 4/2, though it is not properly written in his representation, but he was not allowed to join. And 4/2 is the date when the order of dismissal is issued. Lordship will kindly keep that in mind, Lord. Next page, Lord. Paragraph 3 is, whereas on perusal of past record, this is past record has been brought into consideration in the appeal, which was not there in the original show cause.
Yes.
Now, my lord, this is signed, paragraph 6, my lord. Paragraph 5, my lord, first. There is no need to interfere the dismissal order, and as such, the present petition is rejected. Now, my lord, this is issued with the approval of the Inspector General, South Bengal Frontier. And it is issued by the Deputy Inspector General. My lord, in my humble submission, Deputy Inspector General is not the authority competent, subject to what falls from my lord. This is one. The second thing is, my lord,
Yes.
is this provision rule 22(2). My lord, kindly sees rule 22(2). When after rule 22(2), when after considering the reports on the misconduct of the person concerned, the competent authority is satisfied that the trial of such a person is inexpedient or impractical, but is of opinion that his further retention in the service is undesirable, it shall so inform him together with all reports adverse. Lord, this part has not been complied with, subject to what they will say. They have filed their affidavit, Lord. There they have not said anything of this, that they have not complied with this part. Therefore, my lord, if your lordship knows very well, my lord, if a particular thing has to be done in a particular way, it is that way or not at all. So therefore, it suffers from the vice of malice in law and malice in fact, the dismissal order. Now, my lord, lordship will kindly look at one judgment. In their affidavit, my lord, they have not, brought nothing on new on record. Therefore, I am not placing that, my lord. এটা রিপোর্টের জাজমেন্ট আমি দিয়ে দেবো, আমারটাই দিয়ে দেবো। Your lordship straight away comes to paragraph 16 at page 5, my lord. The question, I'm sorry, the question whether unauthorized absence from duty amounts to failure of devotion to duty or behavior unbecoming of a government servant cannot be decided without deciding the question whether absence is willful or because of compelling circumstances. Here, my lord, this has not been decided whether it was willful or under compelling circumstances.
Hmm.
If the absence is the result of compelling circumstances under which it was not possible to report or perform duty, such absence cannot be held to be willful. Absence from duty without any application or prior permission may amount to unauthorized absence, but it does not always mean willful. There may be different eventualities due to which an employee may abstain from duty, including compelling circumstances beyond his control, like illness, accident, hospitalization, etc. But in such case, the employee cannot be held guilty of failure of devotion to duty or behavior unbecoming of a government servant. This has not been decided at all, my lord. Therefore, in my humble submission, my lord, the question of removal from service suffers from the vice of malice in law, and malice in fact is liable to be set aside. And one more thing, Lord, I don't have a copy of the document which was taken when that authority, when the person came from BSF. But they will be having a copy. Your Lordship will kindly look into that, Lord. What I had written, I don't know. I don't have a copy because it was written and given to them, the person concerned who had come to visit me. When I had said that I'll go to join duties on 4/2, but on 4/2, when I went to join duties, I was not allowed, and the order has been issued.
Where do you stay?
My lord,
somewhere it is mentioned he came back to his home, his wife was fighting with her and everything.
My lord, let me see.
In the appeal.
Farakka. I stay in Farakka.
And your place of work?
Place of work was Roshanbagh, Murshidabad. That is there in the show cause notice.
All right. So it's not very far off.
No. That's why, my lord, they had sent a person.
All right. Maybe. That is the reason somebody was sent. To inquire why he is not reporting to work.
Yes.
All right. 1 minute. Let him finish. Yes.
Nothing more I should submit, Lord. I leave it to your Lordship. Your Lordship has seen the situation.
All right. Yes, please.
Lordship, he is a habitual offender. And please come to page 6, Lordship.
Of
our report. So many proceedings is initiated against him. We have mentioned the case number and everything, Lordship.
Page 6.
Page 6 of our report.
Of your report. Where are the offenses? Paragraph?
Paragraph number 12.
12.
A.
All right.
Roman 1, 2, 3, 4, and 5. We have mentioned all the case details. And the punishment details also we have mentioned.
All right.
Lordship, here, kindly Lordship come to page 11, 12, and 13 of our report. We have sent 3 notices. 7th November 2022, 14th November, and
22nd November.
We had. After that, page number 14.
Hmm.
Come to page number 14 of our report.
Yes.
And under the provision of 62 of BSF Act and as approved by the competent authority, Mr. Rajiv Kumar Singh, AC of this unit is hereby detailed to conduct one-man COI of which the place, date, and the time to be fixed by the prescribed officer. Lordship, after that, we made a representation to the Superintendent of Police, page 15.
Hmm. Hmm.
And we requested, come to page para 3.
Hmm.
It is also requested that if the individual is reluctant to report back to his unit, then he may please be apprehended as per the provision contained in the section 60 of the BSF Act 1968 and handed over to the nearest BSF headquarters. But this authority not replied at all. The superintendent of police not replied. After that, a show cause notice was issued.
This has been annexed.
Yes, Lordship. His submission is that we have not enclosed the document, but we have enclosed the document. This is our submission. We have enclosed all the detailed document, Lordship. After that, within 30 days, he's supposed to reply. He has not replied. He was very much reluctant because it is his habit to be upset. Because of that reason, so many proceedings has been initiated by the department against him. Lordship, that is a final order.
1 minute. Page 17 is this person who you sent to the house of the petitioner.
Yes, Lordship. Lordship, and then
What is the name? 1 minute. The name of the petitioner is
Udip Kumar Pal. And this is Showman Ghosh, who has been sent.
yes,
sent to his house to
Yes,
ascertain the reason for his prolonged absence without leave.
yes, Lordship.
Hmm.
Lordship,
And
come to page 23.
Where is that document where the petitioner handwritten document? He says,
Page 23.
oh, home problem.
Yes.
Acha. Did you not get a copy of this? You said
Page 23 of our report.
No, this was not there.
विनीता निवेदन मेरा प्रॉब्लम घरेलू समस्या कारण
When the department sent a person to his home,
this is what he has given.
Yes, yes. This is what he was given.
Lordship, and another thing.
But he has said specifically on 4-2 I'll join. Fourth line.
Lordship. But he has not.
But he had gone to join and he was not allowed to join.
He is very much.
What is the proof? Why will the court believe you?
Lord, one thing I can only say, Lord. Lord, on 4-2 I am supposed to go and join. And
Yes.
4-2 the order emanates.
Yes. Why not?
Consider. That is my last limb of submission. My other limb of submission remains, Lord. That the document was never given to me. Not this. The COI, report, etc. So, the documents which are now being taken up and shown in the appeal, considered in the appeal, my Lord, they were never there.
Lordship, they have not.
And my
any
judgment, Lord.
that they are, for such reason, they are unable to join. They have not made any representation, and they have not at all claimed that document which here they are asking here. They have not made any representation regarding that document also.
Is there an averment in the writ petition that you did not get those documents?
Yes, I think so. Lordship will
Which
give me
is
a
the
minute.
paragraph? And how has the authority dealt with? Has the authority denied? And this is a report. This is not an affidavit of.
My Lord, page 5, my Lord. Page 5, top.
All right, but then.
Not dealt with.
No, it's not an opposition. It's a mere report.
Ah, that's right. That's right.
It has not
No,
been
no.
dealt.
And he, as a constable, it's not expected of him to be able to write properly. He can carry the gun. He can go and fight, but he cannot do what?
Constable, he can come before this honorable court. He knows, but he can send any representation to the department that he is, for such reason, he is unable to join. Never. He did not bother to reply the show cause notice also. And this is all the case details we have already mentioned in our report. He is a habitual offender. He has already been penalized for that reason. Rigorous imprisonment was there, Lordship.
All right. Had submission made on behalf of both the parties for orders. 22nd.
My lord, could it be given on 21st, 22nd? I may not be there. My lord.
You are not required to be there. I'll prepare my judgment and I'm going to deliver.
Even that will not
23rd. 24th.
Port Blair circuit will be there.
When?
21st, my lord, subject to my lord's
No,
pleasure.
21st will not be possible.
But then
May not be.
after 23rd, my lord, next
27th,
Yes,
28th,
Yes, yes, my lord.
when?
Any day after,
27th.
Lordship. I am grateful to your lordship. ও আপনি জাজমেন্টটা চেয়েছিলেন আমি দিয়ে দিচ্ছি জাজমেন্টটা ওটা জাজমেন্টটা দিয়ে দাও তো
Yes.
আই এম গ্রেটফুল টু
I'm for the petitioner, my lord, led by Mr. Firdaus Samim. He is appeared.
Raise your voice.
I'm for the petitioner, my lord, led by Mr. Firdaus Samim. He is appearing online before the Honorable Supreme Court, my lord. For that reason, I'm praying for not today.
Somebody will be engaged somewhere and the matter will remain pending. Yesterday the matter was dismissed. Nobody was there.
My
The
lord,
court drew the attention of the learned counsel. And today you seek adjournment. Why are the others not prepared in the matter?
my lord, I
Who
don't.
is your other side? Accommodation has been sought for on behalf of the learned counsel representing the petitioners. Stop none appears for the respondents. Stop let notice be served. Released on 4th May. Yes, next.
I appear for the petitioners.
Yes.
English Bazaar Minister.
All right.
My lord, your lordship, kindly come to page 14. This is with regard to transfer of municipal employee. Group D clerk.
Show me the provision of law which permits transfer.
My lord, it's my lord, transfer rule 2010,
Show me, please.
rule 16.
Show me, please. Yes.
Rule 16.
Rule 16.
There is a provision for transfer.
Where? May be transferred from one post to another or from one station to another. Where is a provision from one municipality to another?
One station to another, that is the municipality, because they have already transferred. My lord, kindly come to page 16.
Yes.
The governor is pleased to place the service of Krishna Kumar Singh, presently posted as clerk, Kaliaganj municipality, at the disposal of Sector 5 Industry Township Authority for discharging his duty as clerk, Sector 5 ITA, in terms of Rule 53 of the West Bengal Municipal Employees Rules 2010. In the interest of public service and until further order, under the following terms and conditions. He was transferred. Foreign service.
Foreign service.
My lord, there is provision for transfer. Maybe foreign service.
But you are not. Are you seeking foreign service transfer?
No, municipal service.
Then I don't know. What is your stand?
Lordship, we are not the answering authority.
Yes, local body, director of.
No, where? English Bazaar.
You have applied
Yes.
before whom?
Before the Directorate of Local Bodies.
UDMA, which comes under the department.
State.
Yes, state.
That is the state.
And the municipality of Kamarhati municipality.
What will the Kamarhati municipality do?
The director of local bodies is the authority. Page 22.
স্যার করছেন
Where is your service upon the state? Service upon the state?
My learned senior is not present. First,
It is not here. Where are you serving now?
my lord, now in Kamarhati. I
You want
wanted
to be
posted
transferred to
English Bazaar. My lord, having 2 years old son with
Maybe that is
ailment.
the authority. Please come. None represents the state respondents. Stop. Let notice be served. Stop. The petitioner seeks transfer from the Kamarhati municipality to the English Bazar municipality.
State क्यों नहीं एक जन के दाखिल के लिए तो है ये तो disposal.
Where is your application?
My lord, page 22.
22.
22.
From 24. Her application dated 21st November 2024, annexed at page 22 of the writ petition, is pending consideration before the Director of Local Bodies. Stop. Learned advocate representing the state shall revert with positive instruction with regard to the fate of the petitioner's application seeking transfer. Released 28th of April.
28th. আমাকে ওই রুলটা দিও
Yes.
এটা
Yes.
এটা
Also, I'm the respondent union.
Yes,
Respondent Union of India.
Yes, sir, my lord. I've submitted my.
It's taken up for consideration yesterday.
I was not there, lot more to do urgency had to.
I do not want to know your urgency, but when the matter is there, you should have kept somebody. The learned advocate for the petitioner called you on several occasions and there was no reply. I do not want an explanation. If you are handling a matter, please ensure that you are present in court when the matter is taken up for consideration. Yes, what is...
The case is this, my lord. Initially, he has submitted the VR, my lord, on 12/4/2019, my lord. And thereafter,
Are you ready?
after
Yes.
15 days, my lord, he has submitted a withdrawal application, my lord.
Hmm.
The VR is as per rule, the notice period is 3 months. And within the notice period, he has submitted the
Where is that notice period? Please show.
notice period, my lord. Yesterday of lordship wanted to know, my lord. That is the my lord, as per.
Did you hand over a copy yesterday?
No. Yesterday it was not, my lord. Today, my lord. 3 months the notice period, my lord.
Show me. Which portion?
Which portion, my lord? That is the first month will be, that is. Period of notice, my lord, page number 4. Period of notice, my lord. A railway servant desirous to learn the voluntary retirement, 20 years of the qualifying service should give a notice on 3 months in writing to the appointing authority. A notice is less than 3 months may also be accepted by the applicant, that is a consideration of the GM. When such less than 3 months notice has been accepted, my lord. In the special condition, GM can consider the same. But the specific period, actually normal period is 3 months, my lord.
Yes.
And within that period, the withdrawal has been
And
made.
you have more than 20 years of service?
Yes, my lord.
All right.
That has been there, my lord. And thereafter, his withdrawal application was submitted, my lord. And a page number, my lord, 19 of the petition, my lord.
To whom did you serve the notice?
Lord, the Honorable Divisional Security Commissioner, my lord, Departmental Authority, my lord.
The authority competent to accept the notice,
Noted.
acceptance of the notice is necessary. And the explain. You are a group B, C, D, which
Group C, my lord. Group C, Constable, my lord. Head Constable, my lord. RPF Department.
by the authority, the general manager.
Yes.
Did you submit it before the general manager?
No. But the Honorable Departmental Authority, my lord. Honorable Divisional Security Commissioner.
Honorable Divisional Security Commissioner.
That is stated, my lord, in the application. That is. But in the special case, GM is to consider, my lord, within 15 days or the short period. Before the notice period, if it is considered, then the GM is to be the authority to accept the same. Otherwise, in normal course, 3 months. But that is not the dispute.
It's 3 months, but it is here the authority competent to accept notice is the general manager in respect of Group C or the head of the department. Where the period of, all right, head of the department where the notice is less than 3, he may accept the individual. Otherwise, the departmental head, you have given it.
That is not the dispute, my lord. Only the dispute is withdrawal has been made. But during the period of withdrawal, and he died on, my lord, 30th January 20, my lord. 3rd January 20. During the ailment period, it has not been intimated by the authority that whether the withdrawal has been accepted or not.
Your date of resignation is?
The resignation, no, withdrawal. Date of submission of
submission is 12th of April 2019.
12/4/19. Page number 13, my lord.
Page number?
Page number 13.
30?
No, 13.
Page number 30 or 13.
And thereafter, withdrawal application, my lord, page number 19.
Page number 19. 24th
is the withdrawal application.
All right.
And after submission of the withdrawal notice, withdrawal application, my lord, nothing has to be intimated by the department. My lord, page number 20, my lord.
Yes.
Prayer of withdrawal of the voluntary retirement application, Sunil Chandra Maji, ex-head clerk, my lord. Reference your application received on 11/6/2020. It is totally wrong as because he has died on 3rd January 2020. And how after the date the application has
3rd
been
of January 2020.
20.
He has expired.
He has expired, my lord.
All right.
And how the notice has been served and the notice date has been given, my lord, 3/3/2020.
Yes.
And on that date, he was not no more in the world, my lord. That is.
All right.
My case is this, my lord. That
then what has happened?
Then, my lord, we have our claim is it is a normal death as because the 5-year service was there when he was given the submission.
You want compassionate appointment or what?
Yeah, only the compassionate appointment.
That has been rejected.
That has been rejected with the claim that the once
where is the rejection?
Rejection, my lord. In the reply, my lord.
In the reply, the rejection is
reply
there.
rejection is there clearly. Okay.
And you filed the writ petition in 2025. Why is such
Well, my lord, that is
delay?
earlier, my lord, initially the matter was taken wrongly in the CAT, Central Administrative Tribunal, my lord. Initially, the tribunal has passed an order to consider the same, taking as a normal death or the died in harness. And thereafter, it was challenged before the CAT. And it was wrong for that reason. It has been withdrawal of the same that is filed now, my lord. That is.
All right. Yes. Would you like to rely upon any
Rely upon, my lord,
evidence?
the circular also.
Circular?
I want a railway board circular is there in this respect, my lord. It will be
Yes.
voluntary retirement and railway employee withdrawal of the request of the voluntary. My lord, in the last portion of that, my lord, in the court's order, one relied upon, my lord, paragraph 6, my lord, page number 4. In view of the ruling, as also the rules of the guideline issued by the respondent railway, it is clear that the request for the withdrawal of notice for voluntary retirement, which was received by the respondent within 3 months, should have been accepted of it, was rejected. It should have been done with the valid ground. Since no valid ground was given and are in existence, we are of the view that the impugn order.
What is this? This is a railway board circular, or this is an order you are reading?
Order. The railway board circular. Railway board has annexed this order. The contention is the one order has been passed by the Honorable Allahabad CAT, and that has been relied upon by the railway board, and that instruction has been given. This way, the withdrawal application is to be treated. That is, my lord.
This is in respect of some other
cases, my
employee.
lord. Employees. And after the getting the court's order, generally the railway board is instructed to the all. We accordingly cause this impugn order and the respondent take.
Was the date of death brought to the knowledge of the authority that the employee died on such and such date?
Yes, the application has been made by the widow.
When?
That is the petition, my lord.
Petitioner is the widow.
Petition widow, the first number one is widow and his son.
Who applied for compassionate appointment?
Appointment to his eldest son, my lord. 2 sons and widow.
Where is the application?
Application, my lord, there. Page number 9, page number 20. '25, my lord. Page number 25. And also page number 26, my lord. And death certificate 24.
Page number 25.
25, my lord.
7, my lord.
This is the death certificate 24.
I have applied 24 November 24/20 for the service of my son
20.
on compassionate ground, but I could not mention the particulars. Now the basis of discussion along with the members, Devashish Maji has been selected. The eldest son is recruited as per government rule, my lord.
January 2020 in September, you applied. In November. Page 25, you just now read out. In the middle of the letter, I had applied on 24th November 2020 for service.
2020 November 24th no, wrongly.
Wrong date.
Wrongly 20 on the 24th November he has died in 3rd January. Then actually 24 no, that is 24 November 19. That is. I had applied 21st November for a service of my son on compassionate ground.
He died in January
20.
2020.
That is wrong.
The lady says that she applied on 24th November 2020. And this letter is dated September 2020. How can it be?
No, that is not. Probably that is during this ailing period. Probably that application has been made, but it's 26/9/20. That was requested as the applicant, as the petitioner husband was in ill and continuously, my lord.
Try to understand.
Yes.
There is a stamp 26 September
2022.
The stamp is dated 26th of September 2022. And you write date. All right, I take it as 22.
22.
So,
received 20.
Person died in 2020 and you make application in September 2022.
No, 26/9/20. The left side, my lord.
The receipt, see,
Receipts has been subsequently.
what does it mean?
That is that is. And another application, my lord, that is 23. 19, 23, 23.
The
Yeah,
date
26, my lord, page number.
26 is later on, 23.
23. Yes.
What is the time period within which an application for compassionate appointment is
Yes.
required?
Yes.
2 years.
Yes, ma'am.
So if the person has died in January 20,
Ah,
then it should have been done between January 22.
that-
Your application in September 2022.
yes. No, that received on 2022 was the date of given on 26/9/20, my lord.
It can
And
never
after the
be.
date.
It can never be. Because at the top you write November you applied. How can you apply in November and you
No,
can
that is I'm also
predate the
confused,
letter in September?
I'm confused. But the next page, my lord, is page number 26.
It is 23. It goes.
23, more than her, yes, my lord.
Show me that you made
Claim was
application
confident.
time.
And thereafter, my lord, only initially he was application before the authority, my lord, and on refusal, he has gone to the central tribunal, my lord, and continuously 3 years tribunal was taken the time, my lord, and thereafter it has been withdrawn, my lord, and the claim is continuous, my
I
lord.
want to know when you made the application for compassionate ground appointment. What is your stand?
Regarding the prior letter, apply for voluntary conditions, voluntary retirement, just go through the content of the letter. He was suffering serious medical complications.
Yes.
He himself admitted that anything, anytime something may happen to me.
Yes.
Voluntary the application was rejected. My submission is at paragraph number 8 of my report in the formality. Paragraph number 8.
Yes.
Therefore, withdrawal of voluntary by the applicant was not considered taking into consideration available for return of one source. We state the withdrawal of prior application may be permitted by the specific approval of appointing authority, implying that appointing authority has the power to refuse the request for withdrawal of notice of voluntary retirement, and if there is any material change in circumstances which compels the applicant to seek retirement, that should not involve exception in the contract. However, in the present case, the medical condition of staff has not changed and he continues to suffer high blood sugar affecting his kidney. The medical condition will affect the assistance of starting certain duties. The applicant has himself indicated that anything may happen to him as mentioned in the voluntary retirement application. And as such, withdrawal of voluntary retirement was not accepted as the designation as an accepted with effect from 31st of May 2019.
There is a notice period, right? For
Withdrawal.
accepting or refusing. He filed the application on 12th of April 2019. And he withdrew it on 24th of April 2019. So within a very 12 days, within 12 days, he took it back. Did you communicate your decision prior to that? What is the consequence?
After the application, the process started. The process started.
The process may start, but the applicant always has a right to withdraw the application for voluntary retirement, which the applicant had done. Then what will be the effect?
That withdrawal cannot be considered concerning medical complication. Severe medical complication.
You had this application not been there for voluntary retirement, what would you have done? Did you say that no, you are not medically fit to work and so you are not required in service? Did you say so? You did not say. Then And what will be the status of the employee? When was this communicated to the employee? Your decision to reject the prayer for withdrawal. When was this communicated? And this is by way of an internal note sheet. You did not communicate to the petitioner. Did you communicate? No. Where is it? R5.
Page number 18.
Page number 18.
Of my
Report.
Did you communicate? And when, if you have, where is the proof of communication?
In reference to your application, it is informed that the competent authority has not considered appeal. There is no further scope to entertain the appeal by any other authority.
That is the prayer for withdrawal. The fact of acceptance of the voluntary resignation. Where is that communication?
What is the internal load, page number 14?
This is an internal note sheet. How will the petitioner get to know? Did you communicate? Where is the proof of communication? If you keep something in your note, the petitioner will not get to know whether you accept it, whether you reject it. Where is that? Whatever you have got to say, you've said in your report. How will you add document over here?
It's internal note. After the application, the process started. Internal note was there, indicating the medical complication.
Sir, you should have been ready.
Yes, my lord.
It is your case and it is not the case of the court.
Sorry, my lord. In the report 23, page number 23, my lord. The application has been made by the applicant, my lord. Page number 23, my lord. In the report, page number 23, my lord.
So you are not prepared with your case and the court is hunting through papers to find out where your case is.
5/5/21, my lord. That is the application date is pointed accepted and received on 5/5/21, my lord. That is, my lord. Sorry, my lord. That is.
Are you not understanding that the court is spending time on the matter and you are not ready?
Oh, yes, my lord. That is.
They are relying upon file notings. Will you not come prepared on this issue? Where are the decisions to say that till the resignation is accepted, you have got a right to withdraw it? Where are those? Where is your preparation? Absolutely ill-prepared. The person has expired in 2020. It's nearly 6 years and you are unable to proceed the case. Please come. The petitioners seek compassionate appointment. When can you come ready?
1 week time.
Within a week?
Page number 15, the internal load was acknowledged by
Which one? Internal note acknowledged by the employee. When from?
May 2019.
So every file noting goes to the employee for signature. See, this is the file noting, the employee will sign. Is this how the administration functions in the railways? Seeks compassionate appointment. The husband of the petitioner, number 1, and the father of the petitioner, number 2, died on 3rd January 2020. Stop. Prior thereto, the employee had tendered his application seeking voluntary retirement. on 12th April 2019 and withdrew and applied for withdrawal of the same on 29th of April 2019. Stop. On 3rd March 2020, page 20, the employee was intimated that his prayer for withdrawal of voluntary retirement application is being rejected. Stop. The employee concerned had expired prior to the communication of rejecting his prayer for withdrawal of voluntary retirement. Stop. An application seeking appointment paragraph of compassionate ground was filed by page 21. Petitioner number 1 in May 2021. Stop. The same not being considered, the petitioners approached the Central Administrative Tribunal for relief. Stop. Order was passed directing the authority to consider the prayer seeking compassionate appointment. Stop. The authority considered and rejected the case by holding that the employee was not on service as his application seeking voluntary retirement was accepted by the authority with effect from 31st of May 2019. Stop. The petitioner is aggrieved by the same. Petitioners are. Submission is that the petitioners that the employee had the discretion to withdraw the application seeking voluntary retirement within the notice period of 3 months. Stop. The employee was never intimated the fact of rejection of his prayer for withdrawal of application seeking voluntary retirement during his lifetime. Stop. The employee has to be taken as died in harness and the application of the applicants ought to be considered. Stop. Paragraph. Learned advocate representing the respondents relies on the report prepared by the who is this Divisional Security Commissioner / RPF / Eastern Railway, wherein it has been mentioned that the application of the petitioner seeking voluntary retirement was accepted by the authority and the employee authority, and there is a specific note in the office file signed by the employee. Stop. It has been submitted that the employee was aware that his application seeking voluntary retirement was accepted by the authority and his prayer for withdrawal of the same stood rejected. Stop paragraph. The learned advocate for the respondents is unable to show any document communicating the employee regarding either acceptance or rejection of his prayer seeking voluntary retirement. Stop. Time has been sought to revert with proper instruction. Stop. On such prayer, released on 22nd of April. Fortnight's time is granted to you to revert with document to show the communication made to the employee about his prayer seeking voluntary retirement.
Item number 9.
Yes.
My position. My lord, for the petition. My lord, kindly sees my lord's last order. My lord, this is the matter relating to my lord the show cause challenge of the LICI, which is my lord under the rule of 2009, which is my lord pending for disposal before the Honorable Supreme Court. My lord, if I request your lordship, my lord, to see lordship's last order, which is, I tell you.
No final order to be passed.
Yes.
This was passed in
How-
November 2020. Has final order been passed? Then
Rather, it is admitted, and now, right now, my lord, there has been exchange of affidavit with the Honorable Supreme Court.
yes.
So, my lord, there was a liberty granted to either of the party to mention the matter if there is any change in the scenario.
There is no change.
No change.
All right, please come. The
Your lordship has already
Challenge
passed an
to
order
the-
to this effect.
oh, let me see.
My lord.
Has opposition been filed over here?
No, no,
Let them file and the same order can be passed.
can be passed.
All right, date এখানে
LICI, my lord, in other matters, my lord, instead of filing oppositions,
they are filing report.
my lord, they are, my lord, they have filed, my lord, one application for vacating. So, my lord, that was dismissed, and thereafter they prefer an appeal before the Honorable Division. That is also dismissed, but no opposition is yet filed in any of the matters.
It's mentioned as regards this matter, Amit Kharat and others.
Yes.
Division bench was pleased not
Yes,
to maintain.
yes, yes.
So it is
yes.
here.
Same, absolutely same.
You are representing the Union of India. Who is appearing for the LICI?
My lord, they, lordship will see the names earlier occasion when they appeared. কি নামটা বলতো? Mr. Kundu, my lord, Dilip Kumar Kundu.
All right, today nobody is there. So add up one line, none appears for the LICI, and let this order be communicated to the respondents and to the learned advocate representing LICI.
I'll do that.
All right. And madam, please do not put in names of any counsels who are not present in court. All right.
Great.
May it please your lordship, my lord. This is the, my lord, the exception
Yes.
to the report is being filed today. My lord, prior to placing the order dated 15th of January 2026, my lord, in a nutshell, just I intend to place the fact, my lord.
What is 15th of January 26?
This is an order, my lord. Direction was given to the, my lord, the authority to file a report, my lord.
All right.
My lord, if your lordship sees the order dated 15th of January 2026, my lord, the submission has been recorded over there
and my lord, the Honorable Court has formulated a question of law in paragraph 4, my lord. May I be permitted to place paragraph 4 of the my lord, said order?
Yes. When the
Question
petitioner
arises for consideration
petitions
when the
promoted in
petitioner was on the 3 occasions promoted to the next higher rank after sustaining the injury, why his right to be promoted as the Deputy Inspector General to be denied. Considering the authorities of the BSF is directed to file a report disclosing the reason not promoting the petitioner till date based on the promotional policy, let such report be filed by fortnight such and such. So, my lord, that my lord order has been extended because the report was not filed, and subsequently they have filed the report, and we have filed the exception today, my lord. We have already given the copy. The fact of the case is this, my lord. In the year of 1993, petitioner has been joined. Petitioner joined, my lord, in the BSF as the assistant commandant in the BSF. While he was posted in the Jammu, my lord, he met with an accident and sustained injury while he was returning from his home at Jammu. Then a court of inquiry was conducted for assessing whether the injury would be amenable with the active duty or it is a bona fide government duty. In the my lord, the court of inquiry, the finding was there that it is a bona fide government duty which has been approved by the DG BSF also. So what is the basic difference between the bona fide government duty and the active duty is this? If it is a bona fide government duty and in that event, if he sustain any injury, his category would be downgraded. In that event, he will not get relaxation. But if it is the active duty, in that event, he will get the relaxation despite having his medical status downgraded.
What type of relaxation?
Relaxations means normally in case of a promotion, SAPE 1 is required. The SAPE 1 signifies the different parameters and he has to qualify all the 5 parameters 1. But here, my lord, he sustained injury in the lower organs, then in appendix was sustained injury, then that became the 2. So therefore, he downgraded from SAPE 1 to SAPE 2 in the one organ. Other organ was correct. It was happened and the report was this while he was the assistant commandant. Despite this, the medical condition that he was in SAPE 2, he has been promoted from assistant commandant to the deputy commandant, to deputy commandant to the second in command, and second in command to the commandant now. And thereafter, he already served in different high altitude area also, anti-Naxalite movement and any other insurgency movement also, he participated everything. And even he commanded a battalion also in the Jammu. Now, the time come. In the year of 2023, DPC was conducted. In the DPC, there was no finding. Only, while the other candidature has been considered, petitioner has not been considered because he is the SAPE 2 and his finding was not there, but everything has been kept in abeyance by opening a particular seat vacant. Subsequently, the decision has been taken that he is not fit to be promoted. And then thereafter in 2024, 2025, 2 DPCs have been held. In the 2 DPCs also, there is no reasoning as to why he would not be promoted to the DIG, but it appears that since he is a SAPE 2, therefore he is not fit to be promoted. But in all previous occasions, he has been promoted. So these questions has been formulated. He has submitted a report, my lord. It appears from the report, my lord, kindly, that has been placed like this, my lord. They have given a volume down. My lord, it is in first paragraph 1. So I am placing first paragraph, otherwise, my lord, there would not be any relevance. On the subject case, the requisite reply as they ask, vide your headquarter message. Under the reference has already been shared to your headquarter such and such, vide their number such and such dated 28th of January 2026, followed by their message number such and such 28th of January 2026. However, the specific reason for the denial for the promotion of Johal, commandant such and such Kolkata, from the commandant to the DIG is as under may be apprised to the government council. That the earlier 3 promotions as given to the officer, despite not having medical category of SAPE 1, was the outcome of the independent assessment and the recommendation of the respective departmental promotional committee,
which are vested with the wide discretionary power to evaluate the overall suitability of the officers in accordance with the rules and the policies prevailing at the relevant time, and approval of the DPC recommendation by the competent authority of the MHA of the GUI. So it appears from there that, my lord, they do have vested with the discretionary power. So previous 3 DPC were held and they have exercised their discretionary power in favor of the writ petitioner, for which he have been promoted in 3 occasions. Apart from the discretionary power, nothing has been, my lord, stated over there. At the time of the such earlier consideration, the DPC, upon examining the entire records, performance and the medical status of the officers, found him fit for the promotion under the then applicable norms, and accordingly recommended his promotion up to the rank of the commandant, which was approved by the CA to the MHA Government of India. It was further submitted that for the promotion of the rank of the Deputy Inspector General, DPC was required to assess eligibility in terms of the MHA number such and such dated 31st of July 2007, which prescribes SAPE 1. In all categories, my lord, the SAPE 1 is the requirement. Otherwise, my lord, no promotion would be given. Medical category as the essential requirement, unless the medical downgrading is duly certified as attributable to the injuries sustained during active duty. So there is a relaxation if it would be the active duty. In the present case, while considering the officer for the promotion for the commandant to the Deputy Inspector General DPC, after examining the medical records and the place before it, and the noted that the medical downgrading was not certified as attributed to the active duty as per the existing policy. Accordingly, the DPC, in exercise of the power, did not find the other eligible for promotion. As such, the decision not to recommend the officer of the promotion to the rank of the Deputy Inspector General is a conscious and the reasoned determination of the competent departmental promotional committee based on the extant policy. However, in case of in respect of the all such officers who got injury while promoting the government duty, performing the government duty, not having the medical category of the SAPE 1, is under active consideration with the MHA for the revision of the guideline for the relaxation in the promotion, and the further action will be taken accordingly, while the suggestion has already been sent to the headquarter such and such New Delhi by the past directorate dated such and such. In this regard, the last meeting of the review of the instruction of the healthcare system of the CAPF personnel active duty was also held on 11th of November 2025 by the MHA. Since the matter is presently pending for the decision at the ministry level, until the policy of the decision is received, the existing rules remain applicable. As such, the present medical category of the officers does not fall under the relaxation clause. Apart from the above, the issue in this respect of the above officers to the assessment of the medical fitness of the promotion is under consideration in the Medical Directorate, Force Headquarters, BSF, New Delhi, since 19th of January 2026 for producing before the High Power Committee of the MHA and as per existing practice in force in compliance of the MHA number such and such, in view of the above the Government Council such and such. So now, my lord, the petitioner is going to be superannuated in the year of 2027. He ought to have, my lord, promoted when the DPC was held in the year of 2023. His junior has been promoted for the month of July 2024. Since then, my lord, he is working, my lord, and feeling an embarrassment because he is working
as a junior to
the senior officers. So apart from this, my lord, kindly take today the exception which has been submitted. My lord, this issue has already been considered by the whether which can be categorized as an active duty or not. That aspect has already been, my lord, considered by the Honorable High Court. Prior to that, my lord, just I intend to place my, my lord, exception, paragraph 2, my lord. In compliance with the order dated January 15, 2026, extended by an order dated February 2, 2026, the respondent herein filed a report dated such and such, and the which was served upon the learned such and such.
Don't read all this. Show
Yes.
me the proper portion.
Yes, my lord. So the fact I have already stated in the BC, which has already been stated, my lord. Then D, my lord, this is relevant. Although the medical category of the petitioner was downgraded due to the such accident, but considering his all-round performance and the eligibility, your petitioner was promoted thrice from the rank of the assistant commandant to the deputy commandant. Date has been mentioned in the 3 occasions. The document has been mirrored the annexed. During his entire tenure, petitioner served in the hard area, conducted anti-insurgency
You
duty.
have mentioned this. You
Yes.
have mentioned.
Then, my lord, kindly have a look at the F. Departmental Promotional Committee convened a meeting held on December 29, 2023, and the candidature of your petitioner was deferred without assigning any reason. As such, one vacancy of the Deputy Inspector General was kept reserved for the petitioner. Whereas the fourth recommendation, who were the junior to your petitioner, got promoted for the rank of such and such with effect from the July 1, 2024. In view of such admitted fact, petitioner is facing ignominy. Subsequent meeting of the Departmental Promotional Committee was held on December 10, 2024 and September
No, do not
2025.
read all these things. These are not relevant. What is the relevant portion that you want to show that despite being in shape 2 category, he can be promoted to DIG? Show me this.
My lord, kindly have a look at. My lord, kindly have a look at page 20. Page 20 is annexure 12.
Yes.
My lord, in
20.
paragraph M, kindly my lord, take paragraph M. Admittedly, your petitioner met with an accident near Pulara camp at Jammu while he was posted in the Jammu. My lord, there was a notification. The notification says if somebody will work in that area, it would be considered as a active duty. So this notification I have annexed. My lord, kindly, my lord,
Page.
page 20.
Read petition.
No, my lord, the exception, my lord.
Page 20 of the exception is a gazette notification in Hindi.
Yes, my lord. This is the notification, if my lord, this is in Hindi, my lord.
Yes. What does it say?
It says that, my lord, if somebody served in these locations, it would be considered as a active duty.
All right.
So this has been referred in the 2 decisions passed by the, my lord, the Delhi High Court. I am placing 2 decisions. Police my lord, that has been
let him show the decisions. I'll see.
কপি দাও না 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 আমার কপি আছে তো ইয়েতে এখানেও কপি আছে এই তো সঞ্জীব নারুলা দেখে শুনে বলো কেন দিচ্ছি দাদা দাঁড়াও এটা ভেঙ্কটেশ এটা না এটা অন্য আছে আমি তোমাকে এটাই দিয়ে দিচ্ছি my lord, paragraph 10 to 21.
10 to 21?
Yes.
So many paragraphs, you cannot pinpoint.
No, my lord, the issue was this, that despite being the when that can be considered as an active duty.
You show me that despite being in shape 2 category, you are entitled to promotion in DIG. I do not want to see active government duty, nothing. Show me this.
May I please? Though I was in SAFE 2, I have been promoted thrice. There was no, my lord, the changed policy. The same policy was there. In the same policy, I have been considered thrice. There is no single, my lord, departmental proceeding that I did not perform the duty, despite my, my lord.
It is not a matter of your non-performance. It is a matter as to whether you are in proper shape. According to them, there is shape
at that
1
relevant point of time, when I was in SAFE 2, I was assistant commandant. Then I have been promoted thrice, on the basis of which there is no provision at all that the SAFE 2 can be promoted in 3 occasions. So if in 3 occasions, my lord, they have exercised their discretion in my favor, in that event, my lord, so far is the, my lord, the present condition is this, they can exercise the discretion in my favor.
Can you force or compel somebody to exercise discretion?
Certainly not.
The moment you say discretion,
with humility, my lord, subject to correction, that whenever one authority is exercising the discretion, the parameters are required to be considered. Here the parameters are the same parameters which were prevailing previously and presently also the same parameters are there. In that event, the DPC has to consider whether denial of this opportunity is an arbitrary action or not. Whether they have written down in their DPC that as to why my promotion would be denied, despite that it has been considered in thrice in previous 3 occasions.
Sir, they have disclosed that since you are not in shape 1, you cannot be considered. And when you go to the top, DIG is a very high rank, right? Commandant, assistant, deputy are lower grade officers.
No, this reasoning has not been there. This reasoning has not been there, my lord. And in the, my lord, if your lordship kindly consider the document that the parameters or the prevailing policy which need to be adhered to is the same policy which now need to be adhered to by them. So why I am placing, my lord, the 2 decisions? Because it has been categorically held by the single bench and affirmed by the Honorable Division Bench of Delhi High Court that when a person is working in any capacity, even while he is playing also in their posting, if he sustain any injury, it could be considered as an active duty. So this aspect has already been considered. Similar circumstances, my lord, they were the same 2. They did not consider. That's why, my lord, this issue is under consideration by the MHA. That's why I intend to place, my lord, the 2 decisions where it has been categorized. If your lordship is told that no, now, my lord, this position also, while he has sustained injury, can be considered as active duty. In that event, my lord, the petitioner before your lordship is entitled to get the relaxation. No discretion is required to be exercised.
Yes, sure.
My lord, the page. Paragraph 15, my lord, then 20. There is a difficulty in accepting the, my lord, I have to place, my lord, from paragraph 10, my lord. My lord, kindly take trouble. Because this judgment has been accepted by the Honorable Division Bench, my lord. This court has heard the submission of the learned counsel of both the parties. At the outset, it is required to be noticed that while the SAPE 1 medical category is certainly the requirement for the consideration for the promotion in the terms of SO number such and such dated such and such in the same number such and such, recognize certain medical categories and that are eligible for the relaxation 4.17 read as under. My lord, that has been written down. Therefore, it has been seen that in the terms of the para such and such, a permanent E2 medical category, and which is the categorization as far as the petitioner is concerned, is recognized as one of those medical categories which would be viewed as a relaxation to the SAPE 1 medical category. The further question arises whether the petitioner fulfills the requirement and to be considered eligible for such relaxation. In other words, is the accident suffered by the petitioner as a result of which his medical category in the E2 while on the active government duty in India. Section 2A of the CAPF defines the active duty, means that the duty to restore and preserve the order in any local area in the event of any disturbance therein. The stand of the respondent is that the expression active duty has to be read an administrative genres and with the circumstances mentioned in the para 4.17b, that is the duty which could envisage the field firing, accidental firing, explosions mining, and the explosive devices, or in the other word, the respondents and want to narrow down the expression accidents to only those accidents of the aforementioned kind, not just about the accident. There is difficulty in accepting the submission on behalf of the respondent. A member of the CAPF and does not ceases to be an active duty only because he is not actually in the line of the firing and the dealing with the mines or the other explosive devices. A member of the CAPF continues to remain on duty in whichever post he is, whether it is an anti-insurgency station posting or the peace posting. He is expected to be ready to perform his duty to restore the preserved order in any local or area in the event of any disturbance there. To elaborate, even in a peace station, when the member of the CAPF has engaged in an activity which is formed the part of their assigned duty and suffered on the accident, That accident cannot be categorized as not being incurred while on the active duty. It is the preparedness to participate in all activities to restore, preserve order in any local area that is determinative of whether a person is on active duty or not. For instance, for the peace station, as the part of the regular drill, that the officers have to undertake the maintaining their fitness, an accident takes place, and the which reduces an officer medical category SAFE 1 to SAFE 2, and to be more precise, to the E2 permanent medical category. It cannot be said that and this is on account of the accident and that was not suffer on being an active duty at any point of time, as long as the officers of that station in that posting he may be called upon to perform the active duties, and therefore to restrict the expression accident to only those incurred during the field firing, accident firing, explosion of the mines will not do justice to the intention behind the providing of the such relaxation. Another situation and the could be that and the while an officer is in his dormitory or the barrack or the quarters, there is an accident which occurs and the reduces his medical category from SAFE 1 to SAFE 2. Can it be said that it was an accident while he was on the active duty? In the considered view of the court answer has to be the negative, and an officer continues to remain on active duty. Even in such situation, it will not be justified to categorize such an accident or having been incurred while not on active duty. In somewhat the similar situation of the BSF, where the member of the BSF, while being posted as a company commander, was injured while playing a volleyball match with the company troops deploying under him and sustained an injury on his head, the court held that he has suffered such injury while on duty. In such and such, the court rejected the contention of the respondent that the petitioner in that case had not suffered any injury while on bona fide government duty attributed to his service. The court observed as under. From the above discussion of the inevitable and the possible conclusion is that the evening game and were the integral part of the petitioner's duty. It is also a fact that the petitioner was not exempted from the performance any part of the assigned duty. The respondent have themselves not treated the petitioner as any special case of the low medical category. He was being assigned the posting and the posting just as any other the BSF personnel who was not a low medical category, including the hard posting. The respondent recognized the leadership required as the person for the position of a commander. There is no dispute that the petitioner had to motivate the troops towards the acquisition of the physical fitness by participation in the game. The same is only possible by the officers and the leading from the front. It is therefore had to be held that the injuries suffered by the petitioner on the 14th August of 2006 while playing volleyball at the border outpost and such was suffered by him while he was on active duty. The learned counsel for the respondent then pointed out the medical condition of the petitioner might worsen since it was progressive in nature and therefore he may be found unfit for discharging the duties of the DC. The court clarifies that it is not expressing any opinion on what category of the petitioner should be placed under. The court is proceeding on the basis that at present the petitioner has been placed in the E2 permanent category. If the future point of time the medical category gets revised, then obviously it would be open to the respondent to process the basis of the revised medical category. However, as the now the petitioner continues to be the E permanent category, in the considered view of the court is entitled to the relaxation which provided in the 4.17b5 such and such. In view of the matter, the rejection of the petitioner representation dated such and such is hereby set aside by the court and the mandamus is issued to the respondent to pass a fresh order within 4 weeks, giving the petitioner the relaxation in terms of 4.17b5 SO. The respondent will pass the consequential order such and such. My lord, this order has been affirmed by the Honorable Division Bench of the Delhi High Court. My lord, I will not place in its entirety because it has...
No, it's all right. I take it that it has been affirmed. Yes, then?
The issue has been affirmed, my lord.
Yes.
So my contention is this, my lord. Since, my lord, your petitioner suffered an injury while he has been posted in the Jammu, in two aspects, it can be considered as an active duty, not the bona fide government duty. in the light of the decision and the law laid down, my lord, by the Honorable Division Bench of the Delhi High Court, my lord, subject to your lordship's correction. So, if it is, my lord, considered that although he is a SAFE 2, but if it is a, my lord, the active duty, in that event, my lord, he can be considered for promotion. One. The next submission is this, my lord. Since the, my lord, the discretion has been exercised by the authorities in 3 occasions, now when the DPC has been held, the DPC was not confirmed that whether he should be rejected or not. So therefore, in the year of 2023, they did not take a decision. They kept the matter pending, and everything has been kept in abeyance by keeping one post vacant. Subsequently, when 2024 and 2025 the DPC was held, there is no reasoning as to why I would not be promoted. If someone, my lord, I will not, my lord, apprise your lordship or place before your lordship that the discretion which ought to have been exercised by them should be exercised by the court. But, my lord, they should act in a very fair manner, and it does not show any arbitrariness or any unreasonableness while they are exercising their, my lord, the discretionary power. So this is my respectful submission, my lord, so far as the, my lord, petitioner case is concerned.
I'll hear you after recess.
Actually, madam, just I got the copy of the
Do you want to come back?
No, madam, actually, I have some time, madam. The exception just I.
Achha. Exception of the petitioner filed in court today. Exception by the petitioner filed in court today to the report of the authority is taken on record. Stop. Heard submission made on behalf of the petitioner. Stop. When will you come back? What instruction? This is an exception.
No, madam, exception, some notification is there, madam. That has to be clarified. Actually,
4th of May. You will come back with positive instruction whether for the DIG rank shape 1 is mandatory. That is what is there in your report first. And second, the other promotions that have been granted to him, whether in those posts also shape 1 was mandatory or not. If shape 1 is mandatory in all the other promotional posts, then why are you depriving him at this stage? Followed?
Item number 59.
Yes, certainly. Then
Is here, madam. So,
too eager to contest the election. Accepting, rejecting. It should go on to your left side also. The document should go on to your left side.
Definitely, madam, I am trying to do that.
Yes, what is it?
well, it's
Dr. Kindly please the last but 2 paragraphs. Aforesaid period has been taken up for consideration shall be allowed subject to vigilance and other statutory clearances. A time period of 7 days may kindly be allowed to finalize his application.
The very purpose of his resignation will be frustrated if you take 7 days. And it is pending for quite some time, not that he has filed it
since 2000
recently.
This application is for the fresh prayer for resignation on 10th of March.
Well, that was a fresh pair. Well, kindly come to the documents, my lord. From the
fresh prayer for resignation has been made because it was not initially there.
That was not considered.
Intention. So I said that there is no.
So next time you contest the election, not this time.
Well, the only thing is that it will be frustrating.
What more can I say?
It has to be accepted as a deemed resignation, my lord.
No, you are a doctor, you are not a clerk. There is a difference. Your service is required by the public. Had you been a clerk, you go.
My lord, the only thing is, my lord,
No, but can you assure that he will be released?
No, but I can't do that.
well, kindly then,
Cannot.
your lordship pass an order in that case, my lord,
What?
to direct them to release me, my lord, so that I can, because subject to the formalities, my lord, formalities will be fulfilled.
And then they come up with a decision, no, I do not release you. Where will you stand?
If your lordship may I submit only one thing, my lord. The past resignation, my lord, it was from the year 2022.
No use making all these submissions.
Not the assembly election.
2022 onwards. My lord, this
Promotion.
Yes.
my lord, I don't want to continue with the service. My lord, this
Yes,
certainly
that is the thing.
So,
That is the thing. So contesting the election
no,
is not very important.
my lord, it's not an alibi. I have been nominated, my lord. I will be contesting immediately tomorrow, my lord. So, if your lordship kindly direct that.
No, sorry. Please come. The petitioner's prayer for resignation is under consideration before the authority. Stop. A decision has not yet been taken. Stop.
That's what.
The learned
On
government
the
leader
last order, your lordship directed
seeks
them to
time
take a decision.
to revert with instruction.
This is the recent order.
Order without any decision, my lord.
This is the recent order. What more do you want to?
No, this is not the reasoned order. I do not accept it. Where is the order? You have sought time for finalizing. This cannot be a reasoned order.
Malad, the lordship kindly says this signed by the Malad.
Maybe by this is wrong. You should advise him properly.
No, it has come just now. Malad.
Yes.
It has just now come now.
See, last bold word is 7 days time may kindly be allowed to finalize and the appeal is disposed. Matter is disposed. Pending finalization.
They are doctors. They are not legal experts. They are doctors.
True.
Malad.
Though you are there to advise them.
Malad, we have advised, but it has come not in proper form. I understand. Right?
Revert with instruction. Seeks to revert with instruction as regards the decision on the prayer of the petitioner seeking resignation. On such prayer, released on 12th of May.
12th of May.
A decision on the petitioner's prayer seeking resignation shall be placed before this court on the adjourned date.
Lost it. It is simple. Very well. And next time it will be in a proper form. Malad, next time.
Format is not important. Either say yes or no. He gets his avenue. Otherwise, he is stuck. He don't know where to go.
This is a novel idea, Malad. At the instance of Mr. Chatterjee, I believe, to leave the service.
What is the idea? That is not important. Let us not go into that stage. Thing is, there is an application.
Yes,
Either
there is a yes, Malad. It should be considered definitely, Malad.
I appear for the state respondents.
Apply for the petitioner in this case.
Well, there is a determination issue. It's a service matter. But the classification, I think, is a contractor. I don't know how can he be an employee. I don't know.
Yes.
My lord, two things I want to demonstrate, my lord. What is the case of the, can see the, my lord,
Is it a service matter?
yes, my lord. It is my understanding that it is the service matter, my lord, and coordinate bench.
Where are you employed?
My lord, yes. My lord, kindly see, my lord, page number 14 to my lord, page number 22. All the documents, these documents issued by the my lord, District Inspector of Schools, Secondary Education, Howrah. My lord, kindly see the subject. Work order for submission of quarterly TDS return.
It's a work order.
Yes, work order means, my lord, kindly see, my lord, I have demonstrated.
Do you receive salary from the
No,
state?
this is my lord, remuneration per entry, my lord. I am disclosing, my lord, per entry, my lord, it is a, my lord, 1 rupee. My lord, I have working since, my lord, 2020, my lord, kindly see, my lord, last annex, my lord.
Render services under a work
2020, 2015, my lord. And still I'm working. My lord, our work is this, my lord, to enter the data of the, my lord, employees of the DI concern as well as other teaching of the concern.
Data entry operator.
Yes, my lord. And my lord,
in the
district of Howrah, in the under the district of Howrah
corporation.
My lord, no, this is, my lord, kindly see, my lord, the nature of work.
Schools, I believe.
My lord, kindly see, my lord, the submission of quarterly TDS return in respect of DDO of this office.
Why don't you go before the group
No,
three
my lord.
bench and
Yes,
get it done?
I am telling, my lord, the coordinate
Why
bench
group
is
six?
in similar issue, my lord, the coordinate bench passed the order. My lord, I am seeking only this order. If your lordship, my lord, kindly
Show it to your learned senior friend.
I seen that
Already
order of
seen
Biko
that?
Justice Aniruddha Roy.
Huh?
Justice
This is
Express,
not a case of, my lord,
Justice Roy Express.
education
How
matter.
could I pass this order? I don't know. I was under wrong impression.
Education matter.
No, education matter.
This is,
I
my lord,
understand.
this is, my lord, miscellaneous regarding the service.
What is?
As such, my lord, if your lordship permitted me to go before that bench,
Yes.
residual meter, I am telling your lordship, my lord, residual means purely when a matter is not purview under the group 1 to group 8. And my lord,
contractual matters you can always
contractual,
go.
but my lord, this case is, my lord, I am the working thereof, and my lord, TDS return has been submitted in all the territorial jurisdiction of the district Howrah by the under the
TDS is
supervision.
not important. TDS is not important.
Trade license is important. He says trade license. He's holding trade license.
Howrah Municipal Corporation trade license. It's open in
No,
front of
my lord, this is, my lord,
that means you are in some type of business or a
educational
trade.
respondents, my lord, the district inspector of schools, SC, my lord,
Work
time
order,
to
then
paragraph.
Work order issued in
I
your
am telling
favor,
you, lordship,
you are
that
not getting
even
your
if,
pay.
even if,
Yes, that's it. He
even
will
if
get
there is
possibly
not
he
any
will get
other,
it, but not in this determination.
my lord, even if any other nature of the job, my lord, that should be go before the residuary bench, my lord. This is my submission, my lord.
No, do not press. You go over there. An issue has been raised by the government pleader. You go there. Please come.
As your lordship.
Well, I'm here to assist you, it's not in this determination, but he may get the amount.
But I am telling you, lordship, my lord, that this is the miscellaneous jurisdiction under the, my lord, group 6 matter.
The petitioner is rendering service as data entry operator.
Under a work order,
Under
paragraph 3.
Work order issued by
District
the
Inspector
District Inspector of Schools, Secondary Education, Howrah. His allegation is that he is not getting his remuneration. His allegation is that he has not been paid his remuneration. Stop. The learned government pleader raises an objection with regard to the maintainability of the writ petition under the group 6-service determination. Stop. Paragraph. It has been submitted that the petitioner is a contractual, is on contract, is
He's a proprietorship firm.
Is a proprietorship firm.
Paragraph 2.
Is a proprietorship firm and is working under a trade license issued by the Howrah Municipal Corporation.
Lordship.
Stop. For disbursement of dues, he ought to approach before the residuary bench. Paragraph.
Only this, then Milord, the liberty may be granted to Milord, the rectify the cost.
Yes, I'll give liberty.
Yes.
No, I just wanted to see what order you are relying upon.
Considering the,
This is only consideration.
yes, yes. Milord, and
Representation
Milord,
court was not even made aware of the fact.
and interest part of the Milord not given to me.
That is separate.
Yes, yes.
The court was not even made aware as to what is the reason for the remuneration.
No, Milord, it was
He
Milord
tells his
discussed in the
dues
court proceeding.
And
that the
what-
work order for the job performed by him as contractor.
Yes.
There is no employee.
Yes, your Lordship, your Lordship.
The court is of the view that the petitioner ought to move the matter before the
Residue.
honorable bench taking up residuary matters. ঠিক আছে? In
Classification
view of
of
the above,
parts.
let the matter be released from the list of this bench and be placed before the bench taking up residuary matters. Stop. Leave is granted to the learned advocate on record of the petitioner to amend the classification
part.
as mentioned in the
Costal, yes.
presentation. The presentation, the
form,
front sheet in the front sheet of the writ petition.
Lordship.
Take this order back.
I beg to appeal for the petitioner, my lord. This writ petition has become infructuous, my lord.
All right, learned advocate for the petitioner submits that the writ petition has become infructuous. Due to efflux of time?
No, my lord. I have been terminated, my lord.
All right, very well. Next, in view of the above, the writ petition stands dismissed as infructuous.
Much obliged.
But I appear for the marketing board.
Yes, give your appearance.
But I am for the street.
My lord,
Pardon.
my lord, in item number 13, I am appearing for the respondent, my lord. I am praying for not
Which
today.
respondent?
IRCTC, my lord.
Yes, you are praying for?
Not today, my lord.
Why?
I have been led by Mr. Sarojit Das. He is not here, my lord. He is not present in the court today, my lord.
You are present.
My lord, I do not have the instruction, my lord.
You do not have instruction. Matter is there in the list. Why did you not take instruction?
Lord, I made an application, my lord,
My lord,
seeking
my lord,
seeking interim relief.
Ah.
The matter is pending for hearing, my lord. It is ready for hearing.
Interim relief you did not get.
My lord,
So it has to be heard now.
my lord, kindly get 1 day accommodation, my lord. 1 day.
আমি একবার বলতে দিন 10 সেকেন্ড তারপরে বল।
Ah.
The in pursuant to the direction passed by this court, I went at Bangalore and I joined there. But the IRCTC did not issue me the joining letter, number one. Number two, no formal communication was made. Number two, my salary is not been paid properly.
Because the writ petition was pending, that's why 22 days salary getting.
Because the writ petition is pending before this court, my lord, 22 days
What is
salary
your name?
deducted.
What is your name?
Deep Doctor.
Where is Shoroshij Dashgupta?
My lord, he is not here today, my lord.
Where is Afreen Begum?
My lord, then kindly give a short pass forward. I'll intimate my senior, Ms. Afrin Begum.
We have the issue that we have solved.
Call Afreen Begum. Passing it over.
No.
Yes. Next.
My lord, item number 14, my lord, I am for the petitioner.
I am for the state.
My lord, petitioner was appointed in HIT,
Who
Howrah.
are you representing? State?
State.
Yes.
My lord, petitioner was appointed in the Howrah Improvement Trust as a valuation assistant. Thereafter, he was promoted as assistant valuer. Thereafter, he was promoted as deputy assistant valuer. Thereafter, my lord, he was promoted as valuation officer. All these promotions, my lord, are to be approved by the urban department, government of West Bengal.
Is the KMDA
Yes,
an
KMDA.
important party?
Yes,
Where
yes,
is
KMDA.
KMDA? I can see a report.
No, my lord. According to the affidavits, my lord, I tell you, these are the exceptions, my lord, to the reports filed by state and KMDA.
My lord, our PWP lord.
There is no report of the state or affidavit by the state.
Sometimes. Not I have original code lordship with PWP, my lord, on behalf of state lordship, my lord, kindly with her.
Letter file it. Today not with her. When? Tomorrow?
Tomorrow.
Day after tomorrow.
Sudin আসবে day after.
Friday.
Already lordship office copy and also sharp original lordship with her.
The original should be here.
Yes.
And you intimate the KMDA authority. None represents KMDA. None represents KMDA. Stop. Released. Is there any urgency to be taken up on Friday itself?
No, my lord.
Then I can keep it next week or next to next. Next week we do not have much working days. 20th of April, 20. Let notice be served upon the non-appearing respondent and the exception of the petitioner to the report filed by the respondent numbers 1 and respondent numbers 5 and 6 be written with the records. Next.
So 15, I am for the statement.
The petitioners before Lordship, they were engaged as well as COVID fighter.
They were
Engaged as COVID fighter.
COVID fighter.
Yes, madam. Page 33 is a chart.
Hmm.
Normally, they are known as immunization volunteer.
Hmm.
Subsequent thereto, identity card that was issued in their favor. Now, my lord, a revised pay structure that was introduced, page 54. I have given a type copy at page 55. It's about the immunization volunteers.
All right.
Now that was enhanced to 550 per day. But over this issue, next page, page 56, representation was made. Another bunch of person, my lord, they moved this court, page 68. There was a direction upon the authorities to consider their issue and to finalize the same. That was somehow rejected by the authority. That was challenged by way of second writ petition, page 71, which is important here, my lord. Now, if your lordship kindly takes up page 72, paragraph 5. Learned counsel for the state submits on instruction that the order impugned herein were apparently paraphrased from the different claim, and subsequently copy of the reasoned order has been handed over to the learned advocate for the state, which cites distinction between immunization volunteers and alternative vaccine delivery person, which belongs to the second category. As the discrepancy in payment, it is submitted that the scheme in question applies to immunization volunteers, whereas the present petitioners were alternative vaccine delivery persons who were deployed in a different block of Purulia district. Thus, it is submitted that the petitioners were entitled only rupees so and so per session. Now, this was taken care of by the authority, and ultimately order that was passed, if your lordship turns to paragraph 12 of that order at page 75. In such view of the matter, WP so and so is allowed, thereby directing the respondent number 7, Chief Medical Officer of Health Purulia, to disburse the balance amount. Because the court was of the view that in the referred guideline, as it appears from paragraph 8 and 9, there was no such discrimination or distinction between immunization volunteer and these particular persons.
No, but see, paragraph 12 mentions 550 per day.
Yes.
To the petitioners for the work done by the petitioners as immunization.
So we are the immunization volunteers. Immunization volunteers were also immunization volunteers. Now they are making distinction. Okay. I once again I request your lordships kindly come to page
72.
No, kindly come to page 33. Now, serial number 19. Subhash Chandra Mahato, your lordship got it? Immunization VT, that means immunization volunteer. Within
Everybody is immunization volunteer.
Yes. Now AVD, it's a special duty. Now they are saying AVD is different.
We are within the immunization volunteer. Our role was AVD. They were trying to make this distinction.
Your designation says you are this alternate
Immunization volunteers alternative.
Alternative vaccine
delivery person.
Yes.
And VT is immunization volunteer.
Yes. The kindly have a look at the chart. Chart itself shows
Immunization volunteer.
immunization volunteers.
Within bracket.
AVD.
Got AVD.
This is for the special. You cannot make distinction between these. Now, this was the consideration by the single bench.
Yes. Then what happened?
Now, the authority preferred an appeal, page 77.
Yes.
The appeal was admitted, no interim order granted.
Yes.
They filed another IA. If you let's turn to page 80.
Yes.
In IA, their prayer was that we should not be pressurized to make the payment in terms of single bench order. That has been negated by the division bench and that has been dismissed.
That may be negated, but you do not. All right. Then what happened?
That has been dismissed. That prayer has been dismissed.
And then the appeal is pending.
Appeal is pending. Now, against this dismissal of IA, they went up to Supreme Court. That has been dismissed.
Right.
Now, we are before Lordship in a second round of litigation. Our first round is at page 85.
Yes.
Page 85, there was a direction upon the authorities, like quoting all these things, the direction was passed to consider our prayer. Now, they have rejected our prayer. Page 91. The reasons given thereunder that appears from page 93.
And this is under challenge.
This is under challenge.
All right.
Now, in between, what they did, they made payment to those persons.
In the earlier matter.
Yes. Now,
and you are similarly circumstanced.
Yes. Now, when this matter was moved earlier before the coordinate bench, there was a direction upon me to come with a supplementary affidavit to show that the payment has been made. Now, this is that supplementary affidavit.
All right, give.
A copy has already been handed over to my learned esteems near.
All right. One person has been given, so far the affidavit is concerned. What I see.
If one is given, why not the rest?
We collected the copy of one, but it's our instruction others also.
Appeal is pending. It has
maybe.
It has to
but
be
then it has been implemented.
Well, so far as the payment is concerned, that is done. As he is saying, my lord.
Pay them also?
No. I'm saying, my lord. Whether they are immunization volunteers or they are alternative vacancy delivery persons, that has to be decided. That is
why? That is not the issue.
No, that is the issue.
Where is the issue?
The appeal, that is the issue only, my lord.
What is the page 33? What is the appointment letter that you have given?
Yes.
What is their designation? Immunization volunteers.
Immunization volunteers, AVD, alternative.
That means it is in the same class. But you cannot distinguish in this manner.
Not been regularly appointed, not in a regular process.
It is your problem, sir. You have taken their help during the COVID pandemic. So, and now you want to brush them away.
We have paid as per this. They were to get 90 rupees per day. So we have given that. Now they are claiming 550.
Not they are claiming. There must be some reason for claiming it. They are not. They can claim 5,000 also.
Yes.
But it is not that. There must be some reason as to why they are claiming it.
As per the memo, my lord, they were to get 90 rupees. We have given that amount.
Page 74, now paragraph 9.
Parity with the earlier.
However, no such distinction transpires from the order dated 8th of November, 8th of December 2020, issued by the Health Family Welfare Department of the Government of West Bengal, with categorical fixation of monthly considered remuneration of immunization volunteers engaged under the so-and-so.
Yes.
From where they are getting this distinction?
That is the subject matter of the appeal.
Now, teacher primary and the teacher mother, it's like teacher for science and teacher for arts, they are to be paid differently.
Well, I tried to contact all the persons, my lord, nobody is there. Your lordship will kindly keep it after the election, my lord. I'll take care of this. I'll see.
No, but then this was heard earlier. I can see flaggings and everything.
Yes. By the coordinate bench. And there was direction upon me to come with a supplementary affidavit.
25, it
Yes.
Then you were there.
Yes.
Why will it be adjourned again?
Well, I can only say, my lord, that the appeal is pending and this issue has not been decided.
Right.
So
Please.
far as the payment is concerned, my lord, even if your lordship passes an order, let that be subject to the.
Yes, subject to the result of the appeal.
Extremely grateful, my lord.
I
The
cannot
petitioner-
oppose, my lord. I cannot oppose, but I said whatever.
OA engaged as immunization volunteers within bracket alternate
Alternative
alternative
vaccine delivery persons.
vaccine delivery persons. Stuff. They claim that they are similarly circumstanced as the petitioners in WPA 20093 of 2022 within bracket Orun Baudi and others versus the state of West Bengal and others.
And their second writ petition is 19084, page 71. There the mandatory order has been made.
আচ্ছা তাহলে ওইটা বাদ দিন similarly circumstanced as the petitioners in WPA 19084 of 2023 Upendranath Mahato and others versus the state of West Bengal and others. Stop. In the said writ petition, comma, the court was pleased to direct the Chief Medical Officer of Health to disburse the remuneration at the rate of rupees 550 per day. Stop. The order dated 4th October 2023 passed in the matter of Upendranath Mahato within bracket Supra was challenged in appeal being MAT 647/2024. Acha, challenge in appeal by the state of West Bengal and others. In MAT such and such.
Most importantly, my lord, kindly come to page 79, MAT's order, paragraph 8. They were directed to make payment by the division bench itself.
Acha. State of West Bengal and others versus Upendranath Mahato and others. And the Honorable Division Bench, video order dated 29th April 2024, directed the state to comply with the direction passed by the learned single bench within a stipulated time period. Stop. Challenging the same,
No,
comma,
they came with IA. Page 80, they came with IA. For modification of the order not to pay.
আচ্ছা ঠিক আছে an application seeking modification of the order dated 29th April 2024 was filed by the state, which was considered by the Honorable Division Bench on 16th of July 2024, and the same stood rejected. Dismissed.
Yes, madam.
ঠিক আছে. Stop. An appeal was an SLP was preferred by the state and video order dated 27th of August 2024. The special leave petition within bracket civil diary number 36156/2024 stood dismissed. Stop. On dismissal of the SLP, comma, it has been submitted by the learned advocate for the petitioners that the order passed by the learned single bench has been complied with and payment has been made to the volunteers. Stop paragraph. The petitioners pray for similar relief. Stop. Learned advocate representing the state respondents submits that as the issue in question as to whether the petitioners will be treated as immunization volunteers or alternative vaccine delivery persons is pending consideration before the Honorable Division Bench. Accordingly, payment to the petitioners ought not to be directed. Stop paragraph. Upon hearing the submission made on behalf of both the parties and on perusal of the materials placed before this court, comma, the court is of the opinion that as there is a specific order passed by the learned single bench directing payment to similarly circumstanced persons at the rate of rupees 550 per day, and the said order has not been set aside, comma, vacated, comma, or modified by any superior forum. And on the contrary, the same has been affirmed till the level of the Honorable Supreme Court, comma, there is no reason as to why similar benefit cannot be granted in favor of the petitioners. Stop. It is not the case of the respondents that the petitioners are not similarly circumstanced as Upendranath Mahato and others within brackets Supra. Stop. That being the position, comma, the respondents would be bound to treat the persons similarly, or else the state will be hauled up for discrimination. Stop. Next. The state respondent, the Chief Medical Officer of Health is accordingly directed,
Purulia, my lord.
comma, Purulia, to disburse the remuneration of the petitioners at the rate of 550 per day, subject to the result of the appeal, which is still pending consideration. Stop. Payment shall be made at the earliest, but positively within a period of 12 weeks from the date of communication of this order.
On page 91 needs to be set aside. The rejection.
The impugned order of rejection dated 11th of June 2025 passed by the Director of Health Services, West Bengal, stands set aside.
Grateful.
I'm grateful.
Supplementary affidavit filed by the petitioners in court today be written with the records.
Grateful.
And I am for the respondent number 1, Union of India.
For compassionate appointment. And my father was an employee of the Indian Oil Corporation and posted at Malda.
Who is appearing for IOCL?
I will. My lord, in the post of my lord, foreman. But unfortunately, my lord, on 10th April 2024, he died. But thereafter, my mother got the entire retirement benefit. My lord. Now, in the meantime, my lord, on 25th November 2024, my lord, the respondent authority sent a letter to my mother regarding the rehabilitation option of the unfortunate death of their employee. Now, my lordship, kindly come to my lord, annexure, my lord, P4, page 22.
Yes.
Page 22, my lord. My lord, kindly come to page 23. Option R3 option. Well, I am reading, my lord. This is a dependent employment option. Option under this option, corporation provides.
Did you apply? Did you apply in terms of this?
Yes, I have applied.
Where is this? Where is the application?
That is, my lord. But I applied, my lord. Annexure P3, my lord.
Has it been considered?
No, nothing has been considered. P3, I have applied, my lord. Page 20. Page 20. I applied in the month of 15th May 2025.
Yes. What is your instruction?
Kindly says that this scheme, as per this scheme, 3 options are provided to the spouse. Now kindly see page.
Listen, there is an application. Either you allow or you reject. You cannot keep it pending.
Page 20, P3 chart. 15th May.
If you say that the petitioner is not eligible, let her know.
Well, let me come back tomorrow whether we have given a response to this or not.
What were you doing for so long?
Well, because this letter we have already expressed our mind. Yeah, what is this?
Which
scheme?
letter?
25th of November 2024. What all benefits to be given?
This is November 24.
Yes.
The petitioner's representation is May 25.
Yes.
What is the consideration of this?
Well, let me come back tomorrow whether this has been considered or not.
But till date, by specific instruction,
Whether
was nothing
this was at all received, and if at all it has been received, whether this has been considered or not, kindly let
Show me the receipt of this letter.
well, that receipt is not with me at
Then?
the present moment. At the present moment.
How do you say
But
it was submitted?
let them take instruction, whether they have been received or not. Let them take instruction.
What is your averment in the writ petition as to how you have filed this?
Well, Annexure P3, my lord. Kindly come to page 3 of my application.
What have
Paragraph
you,
5.
what have
That
you
your
stated?
That your petitioner states that after completion of ritual activities of his deceased father on 15/5/2025, your petitioner being an unemployed son made an application for providing a job on the ground of died in
There is no proof of service.
My lord,
There is no proof of service.
well, at the present moment, I have not. Well, let them take instruction whether they have
Petitioner
received or
Petitioner seeks compassionate appointment. The petitioner alleges that an application was filed before the depot manager, Indian Oil Corporation Limited, in May 2025. Stop. There is no proof of service of the said application seeking compassionate appointment. Stop. Prayer has been made to consider the prayer of the petitioner, to direct the respondent authority to consider the prayer of the petitioner. Stop. Learned advocate representing the respondent's IOCL seeks time to revert with written instruction. Stop. Released 22nd of April, fortnight's time, written instruction.
22nd of April.
Let written instruction be produced. Written instruction by IOCL be produced before this court on the adjourned date. Yes, service is taken on record.
Okay.
$17.
Yes, your lord. We are
Appearing for the diversity board.
My lord, I am appearing on behalf of the petitioner, my lord. But one thing, my lord, I must make it very clear before your lordships. I do not know how this matter has come up. It is actually appearing as serial 117 in the monthly list. I have not mentioned, but it has come up.
You are not willing to do it?
No, I am willing to do it, my lord.
All right.
But I must bring it to your lordship's kind notice. 117. In the monthly list, it is running.
Yes.
But it has come up. But I did not.
What come up? All matters are there. All the matters in the list are from the combined list. Did you check up?
No, that I do not know.
You should know. When you are making submission before the court, you should know how it has come. See the list. All matters from the combined list are being put up in the supplementary list in a phased manner, so that the motions are taken up. And if you have any objection, I will adjourn it.
No, not at all, my lord.
Yes.
Your lordships, on the last occasion, the honorable court had directed me to serve upon them and to they
Them means biodiversity.
Yes, my lord, the West Bengal Biodiversity Board. But I was working as chairman over there, and I have not been paid my due remuneration for the period 28th of March 2015
to 27th of August 2018.
You do not need the money.
Why, my lord?
You filed the writ petition in 2025. You are hungry from 2020, 50.
Page 70, I have annexed the order. 70.
And why have you not been paid?
That can only be answered by them. When I made the representation, they have started paying me only from the date of representation.
When is the date of representation?
Yes, my lord.
Representation at para 8. Representation 6/5.
6/5/25. है ना?
6/5/2025.
So what did you do?
Lordship, may kindly sees page 57.
Yes.
57. Airport.